on the record in Kentucky Public Service Commission case number 2017-00179, application of Kentucky Power Company for general adjustment of rates for electric service, order approving its 2017 environmental compliance plan, order approving its tariff and riders, order approving accounting practices to establish a regulatory asset or liability related to the Big Sandy 1 operation rider, and for an order granting all other required approvals and relief. My name is Michael Schmidt. I'm chairman of the Public Service Commission. Seated to my right is Robert Cicero, vice chairman, and to my left, Talina Matthews, the third commissioner on the commission. The proceedings today will be recorded by video, which will be the official record. The purpose of today's hearing is to receive evidence from the parties who have filed motions to intervene which have not been previously ruled upon. Under statute and applicable regulation, a person requesting permissive intervention in a commission proceeding is required to demonstrate either a special interest in the proceeding which is not adequately represented in the case, and two, that the person requesting permissive intervention is likely to present issues or develop facts that will assist the commission in fully considering the matter without unduly complicating or disrupting the proceedings. A person seeking intervention must also have an interest in the rates or service of a utility, as these are the only matters subject to the Commission's jurisdiction. Prior to the entry of the two orders establishing this hearing and how it would ultimately be conducted, two parties were permitted to intervene. One was the Kentucky Attorney General's office through its Office of Rate Intervention, and the second was Kentucky Industrial Utility Customers. And for the record and for the benefit of the other parties, some time ago, the commissioners, even when Commissioner Logston was here, began thinking about doing something more formal in terms of permissive interventions. And it seemed, if going back over the years, prior to even 2009, all of the rate cases that we had had, a number of parties filed motions to intervene and were permitted intervention, even though their interests seemed to overlap, and they seemed not to, many did not present any evidence and seemingly took no part in the proceedings other than to perhaps use their leverage in terms of being required, everybody being required to agree to a settlement in order to leverage some benefit for themselves, which wasn't necessarily a part or shouldn't have been a part of the rate case. So that came to the last rate case we had, Kentucky Utilities, LG&E. There were 13 intervenors, and many seemed to have overlapping interests. And so after the first intervention, after the Attorney General's office, KIUC, was granted, we didn't know who would be intervening or what their interests would be, but decided to basically establish a format such as this so that all could come in and we could see who the intervenors would be and they could explain what their interests were. And so that's what has led us to this proceeding today. In moving forward with the introduction of evidence, we will do that on the basis of the date on which the prospective intervenors filed their motions. The first one that was filed was Walmart Stores East, LP and Sam's East, Inc., which we'll refer to hereafter as Walmart. But as I understand it, maybe Walmart has a witness who has not yet arrived. Is that correct? And if so, we'll just move Walmart back in the proceedings. Yes, sir.
That's correct, Commissioner. We have a witness who's trying to get here. His flights were delayed twice yesterday, and he's scheduled to land in Lexington at 11:15. So we hope to have him here by noon.
Okay, well, that'll be fine. We'll just wait however long it takes. We'll just pass it to the end, and we'll make sure that everybody has an opportunity to be heard.
Thank you.
Okay? There may be another party where that may also be the case, but don't worry. If there's an issue, we'll make sure that everybody's fairly treated and has an opportunity to be heard. One other thing is there are a lot of people here, 8 parties and their counsel, and probably witnesses. You may need, if counsel feels a need to have a private room where you want to talk to your client or your witnesses, there are several available. And I guess if you would like to do that, there's one across the hall and there's one down around to the other side. Ms. Menzel, could you give us the benefit of your thinking on how counsel could obtain a meeting room if they need to or would like to?
If they would just like to signal to one of the staff, we can help you. One of us can help you discreetly.
Okay. Insofar as these proceedings moving forward, since this is a new a new exercise on everyone's behalf, what we will do is I will read the order in which the movements will be heard, and then explain how we will move forward with the taking of evidence and the presentation of that evidence. Walmart stores would be the first to be heard, but since our witness is not here yet, we'll pass Walmart for the time being to the end of the docket. So the first hearing, the first movement to be heard would be Kentucky Cable Communications Association, which filed its motion to intervene on July 10th, 2017. Next, Kentucky League of Cities, which filed its motion on July 12th, 2017, followed by the Kentucky School Boards Association, which filed its motion on July 13th, followed by International Brotherhood of Electrical Workers, Local Union 369, which filed its motion on July 14, 2017, followed by Kentucky Commercial Utility Customers, Inc., which also filed its motion on July 14, 2017, followed by Riverside Generating Company, LLC, which filed its motion on July 14, 2017. And I understand Riverside may have a witness or may be waiting on a witness or counsel may need to speak to perhaps a new witness, and if that's the case and you need some additional time, just let us know and you'll be given whatever reasonable additional time you may need. And last, Progress Metal Reclamation, DBA Mansback Metal Company. Now, the motions will be called in that order, and when called, if counsel for the applicable movement would come forward and probably dispossess Mr. Overstreet and move him over, so you could
I can move over.
you could sit here and then identify yourself and your client and the people you have with you for the record. Before doing that, however, we know the Kentucky Power Council is here. The Attorney General's office is here with counsel, and so is staff, and I suppose the KIUC is here. Yes, sir. Mr. Kurtz. So we'll ask them to identify themselves en banc, I guess, or before we start. Then counsel can come down for the movements and introduce themselves and their clients, call their witnesses, and then we would have cross-examination. Kentucky Power, as I understand it, and correct me if I'm wrong, Mr. Overstreet, Kentucky Power has objected to the intervention of Riverside Generating, correct?
That's correct.
And although has not formally objected to any other intervenor might do so, and will have the opportunity to ask any questions that they might want to ask. And the same would be true. The Attorney General's office may not have any questions, Mr. Chandler, but if you do, you'll have the opportunity to ask. Mr. Kurtz, I don't know if there's any intervenor which is adverse to you or which may be adverse to you. Normally, you wouldn't cross or have anything to say unless there was an adverse witness, but since we don't have any competing, I don't think there's anyone perhaps that competes with your client for standing here, but I'll ask you, what do you think?
Well, Your Honor, I plan to ask questions to only one witness, the Walmart witness, with regard to his pre-filed direct testimony.
Okay, all right, then you'll be permitted to do so.
Thank you.
And of course, Ms. Vinsel and staff counsel will have the opportunity to ask. Because we're taking some sworn testimony, at the end of when everyone has asked all of the questions that they would like to ask, counsel for each movement will be given an opportunity, we're given 5 minutes to make any sort of summary that you might want to make. We've all read the briefs that were filed, the motions, but because there's testimony and questions, counsel, if you choose, you might want to explain again on the record why you think your client ought to be entitled to intervene. And then we'll move on to the next. At the end of the whole proceeding, Mr. Overstreet will have an opportunity on behalf of Kentucky Power to address any one or all that he may choose to do so, and will be given approximately 15 minutes to do it. And if we run a little over, we're not going to cut anybody off. And at the same time, Mr. Kurtz, Mr. Chandler, if you have a statement to make, that would be fine as well. Okay. At this point, are there any questions? I know it may be confusing, and I wish we'd have had an opportunity. None of the commissioners were here last week. We could have established an outline or something to have been maybe more informative for you, but that didn't happen.
Mr. Chairman, would it be appropriate for me to move down?
Yes, I think it would, so that counsel for the parties can then can move forward. I know it's a little unusual for you, Mr. Overstreet. You're now in opposition, perhaps, as opposed to always being the party who wants something. Okay, at this time, would counsel for Kentucky Cable Communications Association please step forward, identify yourself, any co-counsel, your client, and your witness or witnesses.
Good morning, Mr. Chairman and Commissioners. I'm Larry Zilke, and I represent the Kentucky Cable Telecommunications Association. With me is Randy Hollis, and he's going to be the witness as well, Your Honor.
Okay. All right. Do you have one witness or more than one witness?
One witness, Your Honor.
Okay. All right, Mr. Zilke, please call your first witness.
On behalf of the association, we call Randy Hollis.
Okay. Mr. Howard, please step forward. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. Mr. Zilke, you may ask.
Thank you, sir. State your full name, please.
My name is Randy Hollis. I'm the Executive Director of the Kentucky Cable Telecommunications Association.
And to tell the Commissioners, what does the Kentucky Cable Telecommunications Association do?
We represent the investor-owned cable companies throughout the Commonwealth. Our member companies serve approximately 600,000 basic cable customers throughout Kentucky.
And does the association have an office?
Yes, we do. Our office is here in Frankfort, 229 West Main Street, Suite 305.
And approximately how many basic cable subscribers are represented by the association?
Approximately 600,000.
And how many individual companies are members of the association?
We have 14 member companies. 7 of those are directly affected by the potential, the proposed tariff by Kentucky Power.
And why are these members of the KCTA concerned about Kentucky Power's tariff?
Cable companies attach to utility poles to distribute their facilities. That's one of basically two ways that our member companies build their networks. The other is underground in Kentucky Power's area, primarily in the eastern part of Kentucky for our members out there. Underground is not always the best alternative, so we do attach to their utility poles to distribute our facilities and network.
Do the 7 cable companies that attach to Kentucky Power's pole, do they pay for use of those poles?
Yes, they do. They pay under the tariff.
And is there a tariff now that Kentucky Power has introduced that directly affects those 7 members of the association in the tariff?
Yes, it does. The rates for the 2-user and 3-user poles are increasing by approximately 66%. So it's a direct effect to those 7 companies.
Your Honor, I have a copy of the tariff and the proposed increase. Can I make that an exhibit? or-
Yes, you may.
Thank you, Your
Let
Honor.
it be filed as Kentucky Cable Communications Exhibit 1.
Thank you. Do you want the commissioner to have a copy?
Yes, we would like a copy.
Thank
Thank you.
Thank you.
Mr. Overstreet might need a copy
Yes,
as
sir.
well.
Thank you.
Anyone else? Staff? Yep. Let the record reflect that I've handed to the Attorney General and to the staff and anyone who wanted a copy of the tariff, Your Honor. Would you tell the commissioners who are some of the companies that actually pay according to the tariff?
Those 7 member companies include Access Cable TV, Armstrong Cable Services, Big Sandy Broadband, Charter Spectrum, Intermountain Cable, Lycom Communications, and TVS Cable.
And in the exhibit, in the Exhibit 1 that we made to the hearing, Mr. Hollis, does that refer to the existing rate and the proposed rate?
Yes, it does.
And would you tell the commission what does it provide?
The charge for attachments on a 2-user pole currently is $7.21, proposed to go to $11.97. The charge for attachments on a 3-user pole, $4.47 currently, excuse me, increasing to $7.42 per attachment under the proposed tariff.
And also, does the proposed tariff have conditions as to the subject of the attachment?
There are conditions. We've noted that there is an addition there. Our primary interest in this tariff, obviously, is the rate, but we would also want to review those terms and conditions as well.
And are the rates something that cable or power companies apply a certain formula to as to how much space is being used?
Yes. In the United States, the FCC regulates pole rates except in those states that have elected to have their formula, and Kentucky, obviously, as the commissioners know, is one of those states that has regulation over those pole attachment rates.
And does the rates, rentals, and charges in these tariffs of Kentucky Power directly affect these cable companies that are members of the association?
It does affect them. This is a cost center, as in any cost center, when you're looking at a 66% increase, it's an increase in cost which affects the overall operation of the companies.
Is anyone else affected by these pole attachment proposal increased rates other than the cable companies?
Not that I'm aware of.
Has the association intervened in other rate cases that resulted in a change of a proposed cable attachment rate?
Yes, we do. The association typically intervenes on behalf of our members. This is such a specialized part of most tariff filings because it affects cable operators, and that's who we are the cable companies. If we don't intervene, there's really no one else that is really looking at that issue like we would.
And approximately, if this increase in tariff is approved by the commission, what would that do to the rates that are being charged to the Kentucky users?
Obviously, it's a part of the overall cost center, so it could have an effect on the end user.
Is there an issue also that the association brings to bear concerning the amount of equipment and power supplies that are placed on these poles?
That's really an issue that again goes to the per attachment and what is considered an attachment, whether it's just the cable and there are other items that do attach to those poles, such as power supplies. So anything that would count as an attachment.
If the pole attachment costs become high, is that passed on to the customers?
Again, it's a part of the overall cost of business, and as cost of business increase, that can certainly funnel down to the end user.
In the past, when the association has intervened, has the association hired experts to provide expert testimony in support of its position?
We have, yes.
In your opinion, if the KCTA does not intervene in this case, will individual members actually have to intervene, which will be approximately 7 more parties?
Yes, they would have to.
So is the association, if they were granted intervention, does that make it more efficient for the commission?
We think so, and it has typically worked that way in the past. As I said, we typically intervene in any of these rate cases that would affect our members.
And if the KCTA does not intervene, do you believe that any other entity in these rate cases would serve to protect the interests of the members that must pay this rate?
Again, this is such a specialized piece, I guess, of the overall tariff. I don't know that any of the other parties would be actually focusing on this aspect.
Mr. Chairman, Commissioners, those are all the questions I have for this witness.
Mr. Overstreet, do you have any questions for your client, Kentucky Power?
Very briefly, Your Honor. Mr. Hollis, Mr. Zilke alluded to the fact that cable attachment rates are formulaic. Do you agree with that?
Yes.
And that formula is prescribed by the FCC?
In Kentucky, it's prescribed by the Commission.
Okay, and do you disagree with the calculation of the formula?
We have not had an opportunity to look at that calculation. That's one of the reasons we would like to intervene in this case.
Okay. Your counsel was provided with that calculation last week, is that correct? Not Mr.
We've got part of that calculation. We have not been able to, at this point, dig down to we got an overview summary, but we didn't get all of the data necessary to do that calculation.
Thank you.
Anything? Mr. Chandler, on behalf of Attorney General?
Yeah, just briefly. I notice there's an increase in the rate that you previously alluded to on the first page of the exhibit. And on the last page, there's a new second to last page, excuse me. There's an addition of some language in the terms of service for default non-compliance. Is that correct?
Yes.
Does the KCTA intend on providing expert testimony in this matter if they're granted intervention on the numbers of attachments or the definition of attachments that you alluded to, the increase in cost, or the changes in any terms of service?
We've not yet determined that. I would imagine that we would provide expert testimony, though.
That's all the questions I have.
Mr. Curtis?
No questions, Your Honor.
Ms. Vinsel, I apologize. I didn't ask you to introduce your staff that's with you. Would you do that? And then you may cross-examine if you choose.
My pleasure. I'm Nancy Vinsel, staff attorney. This is Jennifer Fell and Jenny Sanders.
Thank you. Any cross?
Yes, we do. Good morning, Mr. Hollis.
Good morning.
Can I have you go back and give me the 7 companies? I wrote it down, but it was a little too
No.
fast.
Not a problem.
Thank you.
Access Cable TV, Armstrong Cable, Big Sandy Broadband, Charter Spectrum,
Now, have you hold a second?
sorry, Intermountain Cable, Lycom Communications,
I'm sorry, could you say that again?
Lycom, Lycom, and TVS Cable.
And do you object if I refer to the association as KCTA?
No, that would be perfectly fine. Thank you.
And their offices are located in Frankfurt. Does
Yes, they are.
KCTA receive service from Kentucky Power?
Do we? No, we do not.
So it is the 7 members of KCTA that you would be
It would be those
representing?
7 members. Those are members of our association, yes.
You testified just a minute ago speaking about raising a question about the equipment or facilities that are attached under this tariff.
Right.
Under the availability of service, there's reference to the attachment shall consume no more than 1 foot of vertical space on any distribution pole owned by Kentucky Power.
Right.
Is there any intent to provide testimony as to the amount of space required for the equipment?
I don't believe so.
In your testimony and in the motion to intervene, you mentioned a special interest in terms of the rates and as you said, a cost center. Could you please explain in greater detail or expand upon that special interest?
Well, I guess the best way to do that is to give you the approximate number of poles, Kentucky Power poles that our members attach to, which is about 85,000. And from the information that we've been given, I think the total number of Kentucky Power poles out there is about 215,000 or so, if I'm correct. I'm looking at Mr. Overstreet, and he can confirm that.
Sorry.
Okay. But anyway, about 85,000 poles. And from what we can gather by talking to our members, and this is not an exact number, but a pretty good estimate as far as we can determine, the majority of those are 2-user poles that pay the current $7.21 rate. Somewhere around maybe 20% or so are going to be 3-user poles, which is at the $4.47 rate. So currently, those 7 member companies in the aggregate are paying Kentucky Power $550,000 on an annual basis for attaching to their poles. Under a 66% increase, I don't have my calculator with me, but it would be considerably more.
And you've provided testimony that there's no other party to this case that can represent KCTA's interest. Could you explain why the Attorney General cannot adequately represent KCTA's interest?
I can only go from the history of us intervening in these cases, and I'm sure that the Attorney General's office has looked at these matters and will continue to look at these matters. But typically, the history that we have here at the Commission, if the association doesn't intervene, nobody is really focusing and drilling down on those matters. And certainly the Attorney General's office could do that.
Similarly, KIUC has been, is a party to this matter. Can you testify as to whether KIUC could adequately represent KCTA's interests?
I don't know that I can answer for them.
Let me rephrase that, from KCTA's perspective.
Again, I think from our perspective, this is the business of our members, and I think in looking at something that directly affects that business, I think the folks that are actually in that business probably are going to be looking at it a little closer.
And if KCTA were permitted to intervene, how would you assist the Commission in fully considering the matter?
We would provide expert witnesses and testimony, as we have done in the past.
I would note that the last case in which Kentucky Power increased the pole attachment rates, it was in 2006, but the case was 2005-00341,
Okay.
and KCTA was granted to intervene in that case.
Thank you.
Are you familiar? This was a while ago. Were you familiar with how KCTA participated in that case?
No, ma'am, I'm not. I was not the executive director at the time.
Well, what I can say is that in that case, KCTA conducted discovery. It filed testimony regarding the pole attachment rates and the methodology, and was also signed the settlement agreement in that case. To go back to the methodology, acknowledging that you have not fully reviewed the methodology, at this point, can you say, are you aware of any changes that Kentucky Power is proposing in the methodology for calculating pole attachment rates?
I don't know. I don't think they are changing the methodology, but again, we haven't, our council hasn't fully vetted that yet.
And again, understanding that there's preliminary work, would KCTA be presenting testimony regarding any changes to the methodology, proposed changes?
If there were proposed changes, I'm sure that we would want to present some testimony on that.
We have no further questions at this time.
Commissioner Cicero, any questions?
Is KATC the only organization in Kentucky that represents cable operators?
We represent the investor-owned operators. There is another association that represents the municipally owned cable companies, and there are a few of those in Kentucky.
Are you part of a national organization, or is it Kentucky only?
There is a National Cable Telecommunications Association, as well as an American Cable Association. Our members, some members are members of one or both of those.
Okay, but you're not a sub-organization of anything national?
No.
I have no other questions.
Commissioner Matthews, questions?
have none.
Mr. Zilke, any redirect?
No, Your Honor, I would like to point out that the Section 224 of the Communications Act of 1934, as amended, Congress gave the Commission power to regulate the rates, terms, and conditions of pole attachments, to provide such rates, terms, and conditions that are just and reasonable. That's what we're looking for, just and reasonable rates. And Congress actually found that without such regulation, they found that it's a unique economic characteristics and the relationship between the pole owners and the attachers, and that's why the Commission has accepted, we believe, the authority to regulate the rates as well, to be fair and reasonable. And we think we can provide valuable testimony, Your Honor, to assist you and this Commission in having a fair and reasonable rate.
Mr. Overstreet, anyone else have anything else?
No, thank you.
Would you, I'm sorry.
Yeah. It just, there was some cross on the Attorney General's representation in this matter. And so,
You may address that.
and if you don't mind, I just want to make a statement on the record that the AG has no intention to address the rates or terms under tariff CATV in either discovery or testimony, nor do we have the resources to do so.
Thank you. Anything else, Mr. Kurtz? Mr. Zilke, would you like to make any statement other than the one you just made?
No, but I appreciate what the Attorney General just let the commission know, and I think that speaks loudly about why we need to be an intervener in this case.
Okay, thank you. If there's nothing further, then you may be excused.
Thank you. May we be excused from this part of the hearing or for the whole hearing?
Well, here's the thing. You can be excused from the whole thing if you like, but recognizing that in the end, that when it's all over with, Mr. Overstreet will probably make some remarks or a summation on behalf of his client, Kentucky Power Company, and maybe Mr. Kurtz, the Attorney General, will as well. So if you may stay if you'd like, or your client may stay, or you may leave. It will not prejudice your position as far as we're concerned, one way or the other.
Thank you, sir.
So it's up to you.
Thank you. Thank you.
Okay, this time would counsel for the Kentucky League of Cities please come forward, identify himself or herself along with co-counsel and any witness or witnesses that may be called to testify.
Good morning, Commissioners. My name is Greg Dutton, and I'm here on behalf of the Kentucky League of Cities. And I have with me today Morgan Sprague, an attorney, excuse me, also from the League, and Mr. Robin Cooper, our witness.
Okay, you may be seated, and please call your first and only witness.
Yes, thank you, sir. We call Mr. Cooper.
Okay, Mr. Cooper, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Please be seated, and you may ask.
What do you say?
Are you ready?
Yeah.
Okay. Mr. Cooper, what is your position with the Kentucky League of Cities?
I am the Chief Member Services Officer for the League.
And can you give us some background on Kentucky League of Cities membership and the services that they provide?
I may. Actually, our members are municipalities across the Commonwealth. We represent over 380 of those cities. We've been around since 1927. We're an association, not-for-profit. We provide a number of services to our cities, pretty inclusive. Legal, training, communications, research, community consulting, which includes strategic plans and comprehensive plans. One of the most important things we do, we advocate on behalf of cities in Frankfort, in front of the legislature, which is what we call Cities United. We represent them one voice in that behalf. We also insure the majority of the cities and all their properties and their personnel, and we have a finance program with municipal bonds and different financing options.
Okay, so within those services, what is your particular role?
Well, specifically, I'm over a number of these. I'm responsible for a number of the services we provide. Generally, I've got my sort of finger on most of them, other than the direct connection to our insurance program. It's a separate sort of floor that, but it does sort of run through the vein of the whole organization. So all those I mentioned previously, I sort of have my finger on the pulse of.
Sure. But just to sort of clarify for the commission and the staff, you are not an expert on utility matters in particular.
Only in a way that as a former mayor I used to pay a lot of utility bills.
Perfect. So have you ever testified under oath in a legal proceeding on behalf of KLC?
No, not under oath.
Have you testified before the legislature?
Yes, I was a former lobbyist for the league and then also for the city of Covington.
Okay. Have you ever been involved in any proceedings before the Kentucky Public Service Commission?
No.
And how long have you been with KLC?
12 years.
Okay. And you said that you were a mayor previously. Which city was that for?
Paintsville.
Thank you, sir. So I'd like to talk about the service territory a little bit. Are you familiar with the geographic boundaries of the Kentucky Power Service Territory?
I am now.
And are you familiar with the specific KLC member cities that are located in the Kentucky Power Service Territory?
Yes, the majority, if not all of them, are members of our organization, and then I, of course, grew up in eastern Kentucky, and I had a periodical distributing company that delivered periodicals to all of these, well, good portion of these cities. So I'm very familiar with most of them.
Okay. And the cities that the KLC represents, those are located basically throughout the Kentucky Power Service Territory, correct?
Correct.
And what is the approximate range of populations that reside within those cities?
Well, Ashland being the largest of about 22,000, goes down to, Wurtland, Pippa Pass, they're in the 200-300 population range.
Sure. Okay. And the amount of infrastructure that requires electric service typically varies along with the size of the population in those cities. Is that accurate?
Pretty much, they're sort of their footprint as far as the city limits is reflective of their population, I would say.
Okay. Now, do some of those cities that we were talking about, do they run their own water and wastewater utilities?
In our research, I think that we came up with all but 5 of those cities have some type of utility, whether it's water, gas, sewer, or a combination.
Okay.
One might have electric service.
Okay. And in your experience, do those city-owned water utilities typically require a pretty significant amount of electricity to operate?
In my experience, yes.
Okay, so they typically have rather large electric bills.
Well, when you say large, I guess it would be reflective of their budget or the size. But yes, it's generally a large portion of what they spend to run their operations.
Okay. And are you aware that one of the tariffs in question in this case is a municipal waterworks tariff?
Yes.
Thank you. So I'd like to talk a little bit about city budgeting for a moment. In your experience, how important is it for a city to adhere to its annual budget?
Well, it's a law. So it's pretty important. Unlike maybe other divisions of government, cities have to, most important, I guess, ordinance they pass every year is their budget ordinance. And then that's the sort of the operational outline that they run their city by.
So if a city has a shortfall during the year, how does the city then cover that shortfall?
Generally through, they would have to cut expenses in some area. Generally the majority of what cities spend their money on is a lot of it is personnel, like most any other entity like that. So depending on how big the shortfall would be, it would possibly cause a layoff or layoffs. Or incidental cuts in a lot of areas, maybe that they could find expenses that weren't as necessary.
Okay. So when a city knows that a particular expense is going to increase the following year, from what source does the city generate the additional revenue necessary to cover that increased expense?
Well, that could be an all-day discussion. To be honest, cities are very limited in their revenue options. Of course, as most of us live in cities, we know that we pay certain taxes, property taxes, and occupational taxes and such. But property taxes are, according to House Bill 44, only allowed to go up in their revenue 4% a year. So it would cause an increase in some type of revenue, and generally that's a tax on the citizens of that community.
Is it possible to just reduce services elsewhere as opposed to increasing revenue?
It is. That's, but in the sort of the public domain, I've never yet seen a city where their constituents ever ask them to cut services. Most of them are more familiar with, I guess, in the political climate of being asked to provide more services than they can actually afford.
Mm-hmm. And are you familiar with the utility's proposal in this rate case to institute a base fuel rate for the lighting classes?
I just recently sort of gain that knowledge.
Okay. And what would you expect that to do to a city's budget?
Well, if they lower the rate, then that would be great, I guess. If it is a fluctuation that increases the cost of a inch or electricity, then I'm sure that would have to be absorbed. And depending on the size of it, I guess it would create budget amendments or increase in that line item of expense. So they would have to handle that as it occurs.
Okay. Just one last question, sir. What type of feedback has the League of Cities received from its membership regarding this proposed rate increase?
Well, we've had limited time to sort of gauge that, but I think we've had about 5 or 6 of our cities that have responded, and all of them seem to be very alarmed by the fact that their rates are going to go up. Of course, any time that a city sees an increase in expense, whether it be electricity or any other expense, they have to pass that on. It has to come, either be absorbed and takes a hit on the services they provide, or they would have to increase some tax or some contribution from their citizens.
Okay. Just a moment, please. What is the size of city budgets in this particular area of the state?
What is the size in particular for each city? Well, the city of Paintsville has a budget of a little over $5 million. I'm familiar with that. I would think that in the smaller cities, their budgets would be into the tens of thousands, and maybe close to 100,000 would be there. I would say the average of all these cities, and this is just looking at them, including Ashland, would probably be in the few $1 million range. But some of these would literally have less than $100,000 budget.
Okay. We have no further questions.
Mr. Overstreet?
Thank you, Mr. Chairman. Mr. Cooper, I'm looking at paragraph 2 of your motion to intervene. Do you have that in front of you?
No.
He does not.
Mr. Dutton, you may show it to the witness if you please.
I can answer a lot better if I see it.
And just let me know when you've had a chance to read
What
it.
are we looking at?
The paragraph 2 for the purposes of this proceeding.
Okay, got you. Okay.
My client always accuses me of engaging in lawyer math, but my count is that there's 26 cities listed here in paragraph 2. Does that sound about right?
It looks about right, yeah.
Okay. Have any of these, have the governing legislative bodies of any of these cities voted to authorize the KLC to represent that particular city in this proceeding?
In this particular, not that I'm aware of.
Okay. And then you also indicate here, and this is sort of dead smack in the middle of paragraph 2, that one of the cities is Olive Hill. You see Olive Hill there?
Mm-hmm.
Are you aware that Olive Hill has its own retail electric company?
I am.
Okay. And that Kentucky Power does not provide retail electric service to the citizens or the entities of Olive Hill?
Well, I think this list, and I didn't put this list together, but these are a list of the cities that are in this area, I think, that are members of our association.
Okay. And in fact, the city of Olive Hill buys its electricity for its electric department pursuant to a wholesale contract that's regulated by FERC. Isn't that correct?
If you say so.
I believe that's all I have, Mr. Chairman.
Chandler, any questions?
Just one question. If KLC is permitted to intervene in this matter, does KLC intend to conduct discovery and provide testimony on the two main issues that you discussed today, which is the base fuel inclusion and the rate with lighting, the lighting rate, and the municipal water tariff?
I believe those are the three rates we discussed.
Does KLC intend on conducting discovery and providing testimony on those issues?
I don't know that we've made a definite decision on how we're going to proceed if we're given standing in this, but generally that is our intention, I think.
That's all the questions.
No questions, Your Honor.
Ms. Mansell, questions? Ms. Fell?
Good morning.
Morning.
Please let me know if you can't hear me at any point also.
Doing good so far.
Great. In your motion to intervene, KLC referenced the lighting tariffs, and you've spoken briefly on how that impacts municipalities' costs and policy decisions. And you also reference in the motion the disparity of rate of return between Kentucky Power's customer classes. Can you expand a little further on both of those for us?
Well,
I'm going to interject real quick on behalf of Mr. Cooper. I'm willing to let him answer the question, but he is not a rate of return expert, and he has pretty limited knowledge of the specifics of the application. Mr. Cooper is here really to sort of establish standing for the Kentucky League of Cities, not necessarily to discuss the specifics of the application. But I'm happy to let him answer to the extent that he can.
Well, thank you. Where is that bus? What I know is that as a former mayor, and as I look at how we review and how we interpret electric bills, and I'm not sure if I'm even going in the same direction you are, but I think that there's, I guess, confusion amongst the ranks of our city officials as to when I've spoke to the ones that I have in the last few days concerning this, there seems to be sort of a deer in the headlight as far as what they're being charged and how that's calculated, especially for the streetlight charges. So I think they're concerned, if I take the liberty to speak for the few that I have contacted, that their concern is first of all, how it's going to be calculated and what the rate is going to be and how that's going to impact them. Is that fair? I don't know if that answers your question. I'm sorry.
Thank you. Yes, it does. And is it KLC's position that no other party can adequately represent its special interests?
Well, we have a history of standing up for our cities. As I mentioned before, Cities United, our association members, which include the number of cities that I guess was mentioned earlier, I think they anticipate us standing up for them and representing them in this type of a situation. I can say that generally when it affects a number of cities, most of these cities don't have the resources to, I guess, appear on their own, nor do they have the knowledge. KLC usually is able to, with an agreement of our executive board, to spend the money to take action like this, to hire the experts or to consult with the people who know more about it.
Could you explain why the Kentucky Attorney General's office could not adequately represent KLC's special interest in this matter?
But I don't know. Ask the Attorney General, I guess, office. They probably know better than I would.
Is that we would like to know from KLC's perspective?
I think that we're unique in the situation is that we've intervened on a number of situations on behalf of our cities. If you can recall, I think we've actually done other utility tariff increases we've intervened on. We do this quite often in other court cases, in cable rates and franchise fees, anything. Cities are, as you can well see, cities are small. They don't budget for defense or to be represented in issues like this. KLC, because of their membership, has the resources and the expectation that we would be the one association, and we are the only association of municipalities in the state. So we through our board of directors, which is made up of city officials across the state, generally they see that as one of our keen responsibilities.
And you've been questioned before by Mr. Dutton about your actual participation in this case, and I know you said there's been no actual decision on how to proceed, but could you confirm that if KLC were permitted to intervene, what steps you might anticipate taking to assist the commission in fully considering this matter?
Well, I think we'd probably involve those cities affected, the city officials, and the actual parties that are aware of what the impact this is going to have on their individual case. As we mentioned, you've got a number of these cities that have utilities, as I did when I was mayor of Paintsville. I know from talking to my general manager, the increases are going to be very substantial. And so they have just the water plant alone in Paintsville, their electric bill is quite substantial and a good portion of their budget. So anytime that you have an increase in something that makes up possibly 25 to 30% of their budget, you're going to see a reflection of that in the rates they have to charge. So it's sort of a pass-through.
Just a moment. Is the Kentucky League of Cities representing itself or the member cities that are customers of Kentucky Power?
The cities.
Can you explain why none of those cities have voted to authorize the League of Cities to intervene on their behalf?
Can I tell you why they haven't? I don't know, other than the amount of time they've had to consider this. Again, as I mentioned before, until brought to their attention, a lot of them are not in a position to do the calculations and to do the math, especially in the street lights. It would be very tough for them to figure out how much or how big of an impact this is going to be on them. Our research tries to put numbers together for them, and we have not completed that. So I can't speak for the city, each individual city, but I'm sure that as in other cases, we would probably have an agreement. We do have emails from a number of cities, 4 or 5, that have more or less just in their response indicated that they are glad that we brought this to their attention and that we are going to potentially intervene in this case.
Thank you. Staff has no further questions.
Mr. Cicero, questions?
So I'm a little confused. You've been asked a couple of times about what type of unique perspective that you bring, and you've talked about budgetary constraints on the cities and the challenges that some of these rate designs bring to these smaller cities. And I'm curious, aren't the calculations already being made by these cities or by Kentucky League of Cities under the current tariff, so that they should know how this mechanism already works?
Well, let me just comment on the street lights. The way I understand it, street lights are not metered, so what most cities get in their utility bill, at least in my experience with the city of Paintsville, we get a number of streetlights that the power company has indicated that we are paying for. And I can assure you that I never personally went out and counted those, but there's a good number of streetlights even in a small town like Paintsville. Basically, I think what I got was well over 600 streetlights in Paintsville. And so then they do a calculation by the size of the bulb or the illumination by kilowatt. And I think there's 2 or 3 different sizes that they put on those poles, depending on where it's located. So those rates that they charged are fixed, at least by them, because they have no way of metering them. I guess they do a calculation internally that tells them how many hours of daylight or of darkness, I guess would be what they would calculate, and then multiply that out by how long that light would be on, and then figure out how many kilowatts it uses per hour or some time frame, and then that's what they charge. So for a city to, especially in maybe a 2 or 3 office or a staff's office in a city, to sit down and do that calculation and try to come up with a number of exactly how or what that impact is going to be, it would be very difficult, I would suspect. At least let me just admit that it was very difficult when I was a mayor. And none of my staff had the expertise to do that type of calculations with any kind of accuracy. Is that fair?
Well, I guess from my perspective, I'm looking at an historical calculation where after a period of time, something would become kind of routine unless there was a dramatic change in the number of poles or the type of lighting that was introduced.
You would think that.
But that being said, so let's go beyond that. Then let's just talk about, so what unique information are you going to provide? Are you going to introduce expert witnesses that will go through this calculation and say from a cost of service perspective, we're being unfairly targeted, or what's the basis for Kentucky League of Cities that you're going to provide?
Well, I think in my reflection it would be an understanding of how this calculation is going to be made and why are we paying the increase and how it's going to be calculated. I think there has to be an understanding of at the end of the day what impact this is going to have on the streetlight tariff especially. I understand there was a utility rate, but I know that my utility doesn't pay a utility rate. They pay different, called large general services, medium general services. I don't know that the tariff is correct or how they apply that tariff. What we've got is, at least in my mind, a little bit of a confusion on who's getting charged what. With our research and maybe a little shining a little light on this, we would be able to determine what our cities and what our utilities need to be charged and if they're being fairly treated under those tariffs.
So will you be going back, the Kentucky League of Cities, going back individually to each of the cities that you indicate here and doing some kind of a collaborated response when these calculations are made, or what's the plan?
I think that's probably pretty accurate. I did that personally on the city of Paintsville. I've had 3 phone calls with them. They've reviewed. One thing, just to further that, what I was stating before, is that you would think that historically that rate would stay pretty consistent. But I can tell you the rate, especially for the street lights, fluctuates every month. And the young lady that takes care of that, who's been there for a number of years, really doesn't understand exactly why that occurs, other than the difference, I guess, in the amount of times the lights might be on.
I won't ask any more questions.
I'm sorry, I can't give you any better answers.
No, that's all right. come out in the general rate case, I'm
Okay.
sure.
Ms. Matthews,
There are
question?
26 cities that are members of KLC that
That's-
are in the footprint.
That's what the motion to intervene has. We have double-checked, and there are actually 28 cities that are in the footprint that are represented by the League of Cities.
Are there cities in the footprint that are not a part of KLC?
I don't believe so. Even the smallest cities, Pippa Pass and I think Wortland, those are all member cities.
Okay.
Yes.
Thank you.
Mr. Cooper, for the record, what is the Kentucky League of Cities and how is it governed?
Well, the Kentucky League of Cities, Mr. Chairman, do you want me to give you a little longer explanation of how we're formed, or
No,
you want me
what
to
I
focus
want
on
you to do
more?
is tell me, is the Kentucky League of Cities governed by a board of directors or a board of trustees?
We are governed by a board of directors, 17 members, made up of mayors, city officials, and representatives from different agencies, city agencies across the state.
Well, that was the question. When asked about whether member cities voted to have you do this, is the Kentucky League of Cities in effect an organization formed and operated by all of its city members?
Yes. And we have another board, which is what we call our large board, which is made up of 53 different representatives from agencies and different cities, which makes up and decides on policies, legislative issues, and such, and gives us, at least our legislative team, and then recommends to our executive board what it is that they feel like needs to be addressed here in Frankfort as far as the legislature goes.
And does the board of directors, what, if any, thing does the board of directors do in terms of hiring officers? Does the Kentucky League of Cities have officers that run its administrative staff?
Well, we have a president of our board, which currently is Mayor Claude Christensen from Sadieville. And then we have Mayor Jim Barnes from Richmond, who is an officer, and then Mayor Teresa Cantrell from Mayfield. All three make up what we call our executive leadership team, and they are the ones that we refer to, and they call the meetings and such.
Well, I guess what I'm trying to drive at here is
Okay.
the Kentucky League of Cities represents a number of cities throughout the Commonwealth of Kentucky, correct?
Yeah, 380.
How many?
Close to 380 cities.
And among those 386 or so are the 28, 26 of which, or 25, were listed in the motion to intervene, correct?
Correct.
And all of those cities, including the ones in Kentucky Power Company's service territory, are all members and have influence by electing the board of directors and the officers of the company. Is that correct?
They are. Yes.
And who was it that made the decision to intervene in this case?
I wasn't a part of that decision, Mr. Chairman.
Well, can you tell us whether or not a decision was made? You're here.
It is, the decision was made, and I would have to speculate that it was made by our executive board. As referred to them as an issue, because they have to have their approval going forward if there's going to be any expenditure of funds. So I would, even though I might not have been in that particular meeting, I would have to say that it was most likely our executive board has approved this action.
Your Honor, I think I'll have to object to that answer. He characterized it as speculation.
Yeah, I understand. With respect to streetlights, to the if you know, if you don't, you just say you don't know.
I don't.
But who operates and maintains the streetlights in Paintsville, Kentucky, when you were the mayor?
Power company.
And when a streetlight goes out, who changes the streetlight?
They do.
And when a decision is made as to what type of bulb goes in the street light, who makes that decision?
I think that's sometimes made, it can be specifically requested, but generally I'll just reflect back on when I was a mayor, we generally left that up to the power company to look at where the pole was and what we were trying to accomplish. If it was a street light that was going to be in like an alley with a lot of trees or such, there was no use in putting a really bigger light in there. But if it was on a city street, well-traveled, we wanted all the illumination we could get. So generally we went by their sort of guidelines that they would determine the size of the illumination.
I have no further questions. Any redirect?
Just a couple. Mr. Cooper, are you aware of the WYMT coverage indicating that Coal Run Village did vote for KLC to intervene in this case?
Yeah, I believe I do. Yes. I recall that now. I saw it actually on Facebook, on our Facebook page.
Okay.
All right.
What is the typical procedure, and if you don't know, that's okay, but what is the typical procedure by the executive board before they intervene or before they file some type of lawsuit?
Well, generally our legal staff will, and our legislative folks will give them all the pertinent facts, explain to them who's impacted, who will be affected, what the projected effect will be, and then the president of the organization would ask for any input, comments, and then it would be asked for a vote to see if they wanted to take any action to move forward with it or to just stand back and sort of stand down on it. Mm-hmm. And that's usually the way it goes.
And so typically no legal action is taken without a vote by the executive board?
Well, Kentucky League of Cities, as a member association, we don't generally take actions unless it is instigated by our cities. They are, that's who we represent. Mm-hmm. We have no direct interest in this other than on behalf of our cities.
Mm-hmm. And your executive board is made up of representatives of those cities, is that correct?
Right. Not necessarily
sure.
these cities, but yes, cities from across the Commonwealth.
Okay. Okay. We have no further questions.
Yes, Your Honor, very briefly. Mr. Cooper, where is the Kentucky League's headquarters located?
Our headquarters is 100 East Vine Street in Lexington, and we have a second office on Battle Alley here in Frankfort.
Okay. Battle Alley, huh?
Yeah.
I'm not familiar with that. You don't have any offices in Kentucky Power Service territory?
Not that I'm aware of, no.
And the league is not the league as the league is not a customer of Kentucky Power?
Not that I'm aware of.
Thank you.
Mr. Chandler?
Just quickly, one statement. The Attorney General's office does not intend to provide any discovery or testimony on the municipal waterworks tariff that was referred to earlier, tariff MW.
No questions, Ron.
Ms. Field? Mr. Cicero?
Did you say that you've never appeared before the Public Service Commission before?
No, I have not.
Has the Kentucky League of Cities ever appeared before the Public Service Commission?
I have to imagine we have. I'm looking at. I wasn't here, but I have to imagine they have.
So at this point, we don't know whether any expert witnesses have ever been introduced by the Kentucky League of Cities in support of an intervener position?
If I may, the league was represented in the LG&E and the KU rate case, and we had a expert witness that offered testimony in that case.
So you have provided expert witnesses in the past?
Yes, sir, we have.
Thank you.
Ms. Matthews?
Questions?
I have no questions. If there's nothing else, you may stand down, Mr. Cooper.
Thank you.
Mr. Dutton, would you care to summarize your client's position at this time?
Yes, I would love to. Thank you, sir. So the League of Cities has felt that historically lighting and city-specific concerns were underrepresented before the Public Service Commission. And as a former Assistant Attorney General who practiced in these rate cases, I understand the limitations on their resources. And so one of the things that typically doesn't get looked at as closely is the lighting or municipal waterworks type of tariffs. And the League of Cities is interested in intervening in these cases partially just to shed more light on those, to make sure that they are carefully examined by all parties as well as the Commission, to make sure that discovery on those issues is robust, and essentially to try and represent the interests of the cities across the state. Just to clarify a couple of things, and we can happy to supplement the pleadings. The Executive Board did vote to intervene in this matter. Mr. Cooper was clearly not aware of that, but that is something that happened. And while there is apparently some misunderstanding about Olive Hill, there are another 27 cities that are members of the Kentucky Power that are represented in this case by the Kentucky League of Cities.
Could you file, I guess, a document showing action by the Kentucky League of Cities authorizing an intervention in this case within the next,
Yes,
by the end of this week, by
Yeah.
Friday,
Shouldn't be a problem.
with a copy to everyone else who's...
Absolutely. We'll file it into the record.
All right, thank you. If there's nothing else, you may be excused, or you may choose to stay till the...
Can we have Mr. Cooper excused for the day? I think that we'll stay.
Yes, yeah. Either you or Mr. Cooper, your witness, certainly may be excused.
Thank you, Commissioners. We appreciate the time.
Okay, would counsel for the Kentucky School Boards Association please step forward?
Morning, Your Honor.
Morning.
Matt Malone, the law firm of Hurt, Deckard & May, and on behalf of the Kentucky School Boards Association, this is Mr. Ron Wilhite, who's the expert witness on behalf of the Kentucky School Boards Association.
All right. Mr. Wilhite, you may take the stand. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may be seated, and Mr. Malone, you may ask.
Thank you, Your Honor. Mr. Wilhite, if you could please, just for background purposes, just explain, number one, your name and your address where you work.
Okay. Ronald L. Wilhite, 260 Democrat Drive, Franklin, Kentucky. I'm employed as the Director of the School Energy Managers Project for the by KSBA.
Okay. How long have you been in that position?
I've been there since March of 2010.
Okay. Before you were involved with KSBA, what did you do for a living?
I was employed by Kentucky Utilities and subsequently LG&E and subsequently LG&E Energy and PowerGen and possibly Eon. I lost track of through all those acquisitions and mergers. But I began my employment in 1968 as a student engineer and continued through the end of 2001.
And while you were there, what kind of involvement did you have? Did you have involvement with rate making, rate design?
Yes, I did. I started in the system planning group where I was dealt with generation and transmission planning, and then moved to the regulation group in 1973, and over the years assumed a number of different responsibilities and roles, ranging from contract and tariff administration to cost of service, load research, rate design, demand-side management, integrated resource plans, fuel adjustment, DSM, and on and on.
So my recollection is, I guess you've got about over 30 years in the utility industry.
Yes, I was there 33 years.
Okay. And during your time working for various variations of KU, I should say, I guess, or LG&E, what boards have you testified before?
I've testified before this commission on numerous occasions, before the State Corporation Commission of Virginia and the Federal Energy Regulatory Commission, and the Kentucky Railroad Commission.
Okay. Could you talk a little about your role with the Kentucky School Boards Association?
Yes, in 2010 I came out of retirement and was engaged by Kentucky School Board Association to help develop and implement a plan to assist local boards of education with compliance to KRS 160-325, which directed them to address rising energy costs that were straining their budgets.
For everybody's clarity, outside of teacher salaries, my understanding is that the utility cost is the second.
Typically, the cost of utilities is the district's second highest cost.
Okay. What successes has the school energy manager project had? I mean, what kind of cost avoidance has this resulted for the school?
Well, statewide, 173 districts have achieved over $123 million of elimination of what I would term as wasteful spending on energy and becoming more efficient in their use of energy. Kentucky is now, through its the efforts of the energy managers throughout the districts, is now third in the nation as a percent of having Energy Star certified schools, which means that those schools are in the top 25% in the nation in terms of efficient use of energy.
2014 and 15, there was KSBA and SEMP. What was the Energy Star Partner of the Year?
Well, KSBA has been recognized 3 times nationally as Energy Star Partner of the Year for energy service efficiency delivery.
Could you talk a little bit about case number 2014-00396? That was Kentucky Power's prior rate case.
Yes, in that case, as part of the settlement that was approved by the Commission, there was an initiation of a pilot school rate for K-12 schools in the Kentucky Power Service territory.
Okay. Kentucky Power, what did they do with respect to meters as it pertains to that pilot school rate?
They have since conclusion of that case, in order to fulfill part of the settlement agreement, have installed, according to my understanding of the testimony, 30 what were termed as low research meters on the schools that would be served currently on the pilot rate. And
how many public school accounts are served on the pilot school rate right now?
There are, according to their testimony at this time, there are 61 school accounts. There are other accounts, school accounts served on other rates.
And how many districts are we talking about that are in Kentucky Power?
There are 23 of Kentucky's 173 public school districts located in the KPC territory.
Okay. Based on your review of the testimony the pre-filed testimony of Kentucky Power to date, what's your understanding of their position now?
Their position is to eliminate the pilot school rate and begin serving those customers on the tariff LGS.
Okay. What is your understanding of the overall increase that the schools are looking at with the combination of the environmental surcharge?
Something in the range of 16% or so. It will impact accounts differently, but the overall average is at roughly 16%.
And while I didn't make copies of this, Commissioners, I was going to reference which witnesses are we referring to for purposes of?
I believe Mr. Buck presents the cost of service study, and Mr. Vaughn makes a recommendation with regard to the elimination of the pilot school rate.
Okay. And subject to check, Mr. Wilhite, but do you believe that is pages 19 of 21 of witness Buck's testimony?
Yes.
And then this is pages 22 through 24 of witness Vaughn's testimony?
Yes.
Okay. And that, for witness Buck, it was section 3, volume of 1 of 4. And for witness Vaughn, it was section 3, volume 4 of 4. Does that sound?
Yes, that's correct.
Okay. If you could talk a little bit about the Kentucky School Boards Association, so that for clarity's sake.
Okay, the Kentucky School Boards Association has been in existence for over 75 years, and its membership is comprised of all 173 public school districts. It's KSBA, I mean, uses an acronym, is governed by 27-member elected by their peer school district board members, and provides a wide range of services, including energy management oversight to those districts.
Roughly how many school energy managers are involved with Kentucky Power's territory?
We have, I believe, 7 or 8. We have one energy manager serves 5 or 6 districts. One energy manager serves 2 districts.
Could you talk a little bit about how the Kentucky School Boards Association became involved in this proceeding? How did they make the decision to become involved in the...
Well, the first step in this is to get authorization from the KSBA's Board of Directors, which was done back in June, I think.
Okay. And has there been communication with the individual districts as well?
Yes, we're in contact with each of the 23 districts that have the schools served by KUs.
Okay. Some of them have passed resolutions.
Yes, it's a rather drawn-out process because you have to hit the board notice, agenda notice, and when a board meets to get action formalized through the board, through the local board of education.
Mr. Wilhite, what's your feeling on schools being a separate rate class in Kentucky Power's territory?
Well, it's definitely my belief that we should now move from a pilot rate to a permanent rate for K through 12 schools in the Kentucky Power Service territory.
And with respect to that, we won't belabor a whole lot, but there are certain aspects of the schools that you view as different than the typical customer.
Yes, there's no doubt that schools, well, customers of a commercial group all have defined operating hours. Schools operate so much differently than retail stores and other customers that might be on that rate.
And for example, like the load patterns for schools?
Well, the load patterns are, yes, because schools operate basically from sometime in August to either late May, late or early June in terms of a full, and they operate in a full occupancy mode from basically 7:30 in the morning to 2:30 or 3 o'clock in the afternoon. The rest of the time, schools are not fully occupied, and their usage is significantly different than compared to a retail operation that would be operating 7 days a week, possibly from 7 in the morning to midnight.
If you could explain why you think that the schools have a special interest in this proceeding and that couldn't be represented by the Attorney General, for example.
Well, certainly we have an interest in sustaining the school rate. We also have an interest in some other aspects of the filing. For instance, we're and I've done my first high-level read of the case, but we certainly want to explore on discovery the proposed GS minimum application in the proposed GS tariff. Schools, because of their seasonality of their load, are sometimes pay minimums that maybe other customers don't pay. We have some interest and appreciate the Commission combining the proposed bill format with this proceeding. We certainly aren't opposed to simplifying the bill, but there's a balance between simplicity and being able to audit and validate your bill. And by rolling in all of the charges, the customer demand and energy and minimum bill application all into one line, it makes it more difficult for a customer and our energy managers to validate that bill and also quickly identify possible malfunctions in their control systems and being caught in a mode of paying the minimum associated with with a billing demand, which could have been avoided had their system not malfunctioned. So we had some real interest in discussing with the company on how we don't lose track of that ability for our energy managers to continue to function effectively in their review of the operation and use of energy in their buildings.
With respect to the school energy managers that are in place in Kentucky Power's territory, do they monitor the bills? Do they provide ongoing information to you?
Yes.
Okay.
Yes, we are tied to them through contract, and we set forth in those contracts certain job responsibilities for the energy managers and certain goals and reporting responsibilities. As a matter of fact, we're now bringing in the last quarter of the just finished school year in order to complete our annual report for the schools.
So is it fair to say that while the Attorney General does represent all ratepayers, they don't have as intimate a knowledge of the specific aspects involved with the schools?
Yeah, I believe that to be the case. I think we're in a unique position with KSBA with what we can bring in terms of regulatory rate-making experience, cost of service, load research, rate design, combined with our knowledge that we've gained through the energy managers about the detail operation, not only detail operation of the school, but the detail usage of how they use energy. I think we're in a unique position. It would be difficult for the Attorney General's office, as good as they are, to replicate that.
And with respect to testimony that you intend to potentially present if the Commission were to grant intervention, I know it's early in the process, but do you have any ideas about what you may be looking at?
Yeah, well, certainly, we're I'm sure as everybody's concerned about the amount and the frequency of these increases and where are we really going over time. Certainly, the primary thing we'll be looking at providing to the Commission for their ability to make the decision to sustain the school rate as a permanent rate, providing testimony on that. I'll be looking at their cost of service study, their load research, and their rate design with regard to that. And I mentioned a minute ago about the proposed, the GSB minimum in the tariff, the bill format. Also, I noted an inconsistency in their time of day, their periods of peak and off-peak demand application between their tariffs. That just I'm be interested to know why that's the case, because there's potentially some point in time that these tariffs could become time differentiated for schools.
No further questions.
Mr. Overstreet, questions?
Thank you, Mr. Chairman. Mr. Wilhite, does the School Board Association have an office in Kentucky Power Service territory?
The wheel was dry there for a moment. No, we don't.
Okay. And just for purposes of clarity, the School Energy Manager Program, that is separate and apart from the pilot K through 12 tariff. Is that correct?
Yes.
Okay. That's all I have, Your Honor.
Mr. Chandler?
Just briefly, Chairman. I just want to confirm, is it your understanding that if permitted intervention in this matter, that the Kentucky School Board Association intends to conduct discovery or provide testimony on any and all of the subjects of the school energy management program, the pilot school rate, and cost of service?
Yes.
That's all the question I have.
Mr. Kirk?
I just have one question. Mr. Wilhite, this 16% rate increase that you cited, that's the gross increase, correct? That's not net of the additional revenues that the school districts will get from the 3% utility gross receipts license tax. That's correct?
Yes.
Okay. Have you done the calculations of how much extra money the schools will get from this 3% tax on business customers located within the school district footprints?
No.
But that sometimes that more than offsets the rate increase for some districts, doesn't it? So they actually make money on rate cases?
It possibly could.
Thank you.
Staff?
Yes. Good morning. Earlier you mentioned there were, I believe, 161 school accounts being served, I'm assuming, under the K-12 school tariff, correct?
Yes.
And you did mention there were some accounts on other rates. Are there any other tariffs or rates at issue in this general rate case that KSBA is particularly concerned with?
Certainly will be. There are accounts currently served on the SGS tariff and the MGS tariff. Schools typically have a number of accounts. Those served on the pilot school rate are primarily would be the school building, but schools have pumps and concession stands and ball fields and all different kinds of other uses of energy.
And you've already detailed a little bit for us about your special interest as to the K-12 tariff, the desire to continue that as a permanent rate. What about these other tariffs, the SGS and the MGS? Can you expand any further on any special interest in those?
Not at this time. The thing that the company has done, they are proposing to eliminate the SGS and the MGS tariff and combine that into a, I think it's GS tariff, which would be for loads of 100 kW or less. And so we're not at the point of having fully done any analysis on those tariffs yet.
Going back to the K-12 tariff, can you confirm that the terms of the settlement agreement provided that tariff would remain in effect until a final order is issued in the company's next general rate case, and that the tariff will be reviewed using the available load research data to evaluate whether or not to continue that?
I think I could confirm the part about the load research and the review. I just don't remember what it said about a final order in this case.
Thank you. And what is your understanding of the purpose, what the purpose was of establishing the pilot tariff?
Well, to see whether or not schools were, as I was advocating, are different than other customers that would be served on the LGS tariff.
And what's your understanding, just sitting here today, just in general, of what Kentucky Power is proposing or has found?
Well, they're proposing, I'm not sure what they found, I guess. They're proposing to eliminate the pilot school tariff.
And there's been some testimony regarding the bill format. Can you expand for us upon how the school energy management use information and how bill format change impacts KSBA's ability to gather information?
Yes, they each with receipt of bills each month, the energy managers are positioned with what we call utility trackers, and they'll record the information from the bill into a spreadsheet where they can accumulate by account the detailed information, and then that enables them to one, validate the accuracy of the bills, from a higher perspective, see whether there's some change in usage that should be attended to, and then also provides them the ability to work with us to monitor and measure the impact of the efficiency measures that they are putting in place that we include in our annual report back to Kentucky Power and it comes to the commission. So that it all starts with having access to data, and also in this case, I mean, we'll have the ability with that detail for the district to individually determine the impact on their districts from this proposed increase.
Thank you. Staff has no further questions at this time.
Mr. Cicero?
So how long has the pilot program been in effect?
It began July 1 of 2015, so it'd be two years.
2+ years.
Yeah.
long enough to have your energy managers gather enough data to make a determination of whether it's successful, it's valid, it should be invalid?
Well, it's of course, they were gathering data long before the pilot rate. I think what the pilot's enabled to do is to provide for Kentucky Power to put in place the load research meters to get more detailed information than comes about with a typical monthly bill that a customer receives. And then they in turn, Kentucky Power, or the person could then do a cost of service study with that information.
So is it Kentucky School Board's position that the pilot program should be eliminated, but the rates made permanent?
Well, our position is that the tariff, a school tariff, remain permanent. Now, the rates are going to be subject to whatever the outcome would be in this proceeding.
Let me ask the question a little bit differently. They propose to eliminate the pilot program, the tariff for it, correct?
Yes.
And you agree with that, but you don't believe that the rate should fall under the new tariff that they've proposed. The Kentucky School Board's position is that it should be, the rates that were identified should be made permanent in the pilot program.
I think we're close to mixing terms here, Commissioner. That the word pilot would be taken off the tariff sheet, and it would be a school rate.
Right.
The charges on that, I guess, the charges would be subject, as expressed on that tariff sheet, would be subject to the final order in this proceeding.
Its own separate tariff.
Yeah.
I think we're talking about the same thing. I just want you to confirm that that's what we're talking about. So you would provide some kind of cost of service study expert that would say, based on what Kentucky Power provides for that territory, that would support the rates in that separate tariff?
We may. The company's filed cost of service study shows the pilot school rate earning about over 1.5 times the average company rate of return. So to me, that's a big piece of information right there. In that the schools served, the 161 schools are not getting any sort of preferential treatment. They're more than paying their way under the pilot.
So at this point, you're going to provide some kind of supporting testimony or information that will look at those rates under a separate school tariff as opposed to putting it under the general tariff?
Yes.
Thank you. No other questions?
Commissioner Matthews?
How are the energy managers paid for currently?
They are paid, we have an arrangement that was approved in the last case with Kentucky Power, incorporated a school energy program into their demand-side management tariffs. And so funds that are coming from that program are used to provide a match of the salaries for the energy managers. So the energy managers are paid for part through the grant, part through the local district, and part through the state, because the state picks up the retirement and health cost of a certified employee, which these folks are in the districts.
Are you going to be providing evidence on the energy managers program? Because your intervention really addressed only the tariff.
Yes, we probably will. It's good. Yes, we probably will, yes.
Is there something in particular you're going to focus on there?
Well, yes, I'm aware that the commission has expressed a concern, I guess, to put it, about demand-side management programs in the Kentucky Power Territory, and the school energy managers is a demand-side management program. So we've got.
And I guess that was my confusion, is that it is a demand-side management.
Currently,
it's in that compartment.
Yes.
Okay. But there was, in the settlement in the last rate case, or was it in the Mitchell case, that directed some school energy managers?
If I recall, this is subject to check, I believe the Mitchell case, the company committed to making $125,000 of shareholder money available for use for school energy management in Lawrence and contiguous counties.
Okay.
Okay. And then in the last rate case, as part of the settlement, the company committed to making $400,000 available for school energy management in all 23 Kentucky Power served districts over the period 2000 from school years 16 and 17.
Okay. Thank you, I don't have any more.
Mr. Wilhite, I guess the question was asked by Mr. Kurtz about the, I guess, tax, I guess an energy tax or a tax on some other customers or customer classes for use of electricity. Do you know if every school district in Kentucky Power Service area has enacted that tax?
I do not.
School boards do have taxing power, though, do they not?
Yes, subject to the typical, after I think KLC witness, after the House Bill 44 was constrained, and it is subject to voter recall typically for tax increases.
Well, they can, if they don't take the nickel tax, they have the option of a 4% increase or take a compensating rate. Is that correct?
Yes.
Some schools in Kentucky Power's area have their own energy management programs that are separate and apart from the settlement agreement between Kentucky School Board Association and Kentucky Power Company. Isn't that correct?
That's correct. Now, we're available to support any of the 23 districts. It's just that only 17 of the 23 districts have taken advantage of the direct funding to support their energy manager. Some of those 6 districts have not ignored energy management, but they've gone about it in a different way by contracting for what's known as a performance contract, where they engage a third party to come in and replace older, inefficient, antiquated equipment with more modern, new equipment, and they use the savings from that replacement to pay for the new equipment.
Lawrence County Schools has done that with Honeywell.
They've done that. They also have an energy manager.
In fact, they were one of the first in the state.
Yes.
All I'm saying is, I guess, is that independent of settlements or agreements in these cases, school districts acting on their own have the ability to lower basically their electricity rates or their payment for electricity.
I would
Is that
agree.
correct?
I would agree. They have the ability. I'm not sure they always have the interest in doing it, or nor did they have the funds. Otherwise, I don't think the General Assembly would have enacted KRS 16325 to basically gently force.
Well, in reviewing for this hearing, one of the things that I didn't understand all of the intricacies of these settlements in the prior Kentucky Power cases. But in one, there was in an order, Kentucky School Board Association was to provide Kentucky Power Company with some kind of information on a semi-annual basis as to electric usage. And I didn't know, did Kentucky School Board Association do that?
Yes, sir.
Okay. The reason I say that, and I don't want to fuss at Mr. Overstreet or his client, but I couldn't find, or nobody here could find, if that information was ever submitted to the commission.
Yes, Your Honor, and I think it's actually submitted on an annual basis, and we've made that filing every year since that settled.
Okay. It may be that I may have to ask you in a data request to provide that additional information to us, because I had asked and we hadn't been able to find it, but that may not be necessarily unusual. Anyway, thank you very much.
Sure.
Do you, And I know this was your pilot project that started, I guess, in, 2015. And now, in a previous rate case, you testified, I guess, in the Kentucky Utilities Louisville Gas and Electric rate case, and the commission asked about including non-public schools in the classification, and I understand that you've already submitted a plan, Kentucky School Board Association, for doing that.
Yes, we have.
Is that correct?
Yes.
And I know that you can't represent, Kentucky School Board Association can't represent non-public schools, but if in this case it came to a point of assuming that a special school tariff were made permanent, do you have any reason to believe that that tariff would not be applicable or should not be applicable to non-public schools?
No, sir.
All right, no further questions. Councilman?
Just in summation, Mr. Chairman.
Well, I guess since we've asked, some of the other, Mr. Overstreet may have he may have a pointed question or two.
I don't know how pointed it is, but Mr. Wilhite, the pilot K through 12 tariff that the School Boards Association is interested in making permanent and that the Vice Chairman asked you about, it includes, does it not, a $500,000 annual subsidy?
Well, it produces $500,000 less than it would otherwise produce on a rate LGS. But the rate itself, as shown by the cost study, is producing a rate return of over 1.5 times the system average. So I don't term that a subsidy.
Okay, well, and maybe that was not a good term, but as you indicated, the pilot rate actually produces $500,000. It's designed to produce $500,000 a year less than would be produced under the LGS rate. Is that correct?
Yes.
And most schools would probably be on the LGS rate. Is that correct?
Yes.
And so
most schools. Okay, there are other accounts, but most schools, yeah.
And do the other LGS customers make up that $500,000 shortfall?
I would have to go back. It was all part of the settlement and revenue allocation in that last case, so I don't know whether
that's all.
How that was done.
Nothing further.
No question.
Staff?
No further questions.
Any commissioners? Anything else?
Thank you.
Mr. Malone, if you'd like to, you may be excused, you may step down, please. Mr. Malone, if you'd like to make a short summation, please feel free to do so.
Thank you, Mr. Chairman. And just looking at the reg for intervention, basically what we're looking at is whether or not the Kentucky School Boards Association has a special interest that's not otherwise adequately represented. I think that Mr. Wilhite did a fairly good job of explaining why the Kentucky School Boards has a special interest in looking at the prior Kentucky Power 2014 case. We've got the pilot that's in place that at this point they are looking to terminate. I think it's with that alone, without even getting into some of the other issues that Mr. Wilhite had referenced, I think that generally speaks to the special interest that the Kentucky School Boards Association has in this matter. I think you couple that also with the fact that the school energy manager provide information, and that provides us a basis that is a well of information that I don't, no offense to the Attorney General's office, but I don't think that's something that they would want to get in nor need to get into, because I think we already have the information, we have an intimate knowledge about that. Therefore, basically, the Kentucky School Boards Association would have, number one, a special interest, and number two, that's not otherwise adequately represented. Thank you.
You may be excused. Mr. Montague and your client may stay or leave at your option.
Thank you.
You're welcome to stay, but if you don't want to stay, we understand.
Thank you.
All right, we've been going for 2 hours. Why don't we take a break until 10 after 12 and then come back and we'll try to start again with International Brotherhood of Electrical Workers.
Your Honor.
And in between time, if someone would like to talk about lunch or whatever, we can do that.
Is it your plan to push through without taking a lunch break?
Well, what I had planned to do is during this recess, lawyers can talk about it with the commissioners, and then we can see how we want to move forward. Is that fair?
For your consideration, it would be my strong, I have to get back to the office, so if we could just go right through lunch, it would be, I'd
Okay.
appreciate it.
Well, during the
But
break, then we'll take a poll and see how it works out, okay?
Thank you.
All right, we're in recess until 10 after 12. Week, discussions with council for all of the parties, including staff, council and staff. Everybody has agreed to keep going and waive, I guess, a lunch break. That's all subject to if someone feels the need to have a break or get something to eat, we'll take that into consideration, but you just need to let us know, okay? I know everybody was ready perhaps to start a few minutes early, but in my experience as a trial lawyer, there's nothing worse than coming back on time only to find that somebody started without you, or as at least one of our federal judges in the Eastern District has somebody locked the courtroom so you can't get in. So anyway, so I'm sort of lawyer-friendly in that regard, so we'll always give counsel and everybody a chance to come in before we start, even if it's a couple of minutes late. So Mr. Kurtz has a plane to catch later this afternoon, so it's been determined that when the Walmart's witness comes and counsel for Walmart has had an opportunity to talk to the witness and prepare the witness, we will then insert them back into the lineup because Walmart should have been the first witness under our order of proceedings anyway. So we'll, when they come, we'll proceed accordingly. But now the next party to come forward is counsel for International Brotherhood of Electrical Workers, Local Union 369. Would counsel please identify himself, any other counsel with him, and his witness?
Good afternoon. My name is Ben Basil. I'm an attorney for International Brotherhood of Electrical Workers, Local 369. My witness is our business agent, Ed Devine.
Okay, Mr. Devine, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may be seated, and counsel, you may ask.
Thank you. Ed, would you please state your name for the record?
Ed Devine,
And where are you employed?
IBEW Local 369 in Louisville, Kentucky.
And what is IBEW Local 369?
International Brotherhood of Electrical Workers.
And it's a labor union?
Yes.
And what type of workers does the union represent?
Electricians in various aspects of the electrical industry.
And what position do you hold with the union?
I'm a business rep.
And what does that mean?
I currently represent maintenance contracts. I've got 16 contracts. I represent anywhere from Brown Forman to TV stations, WLKY.
And what type of work did you do before you became a business agent with the local union?
For 20 years, I was an inside wireman.
And that means you're an electrician?
Electrician by trade, yes, sir.
Does the IBEW Local 369 represent employees of electrical contractors that are employed by Kentucky Power?
Yes.
And approximately how many contractors and how many employees do we represent?
Contractors, I wouldn't know the exact number on the contractors, but we represent roughly between 375 to 500 employees that do work as tree trimmers and outside linemen.
All right, so you referenced tree trimmers. Are there, the union represents both people who are electricians and people who are not electricians that work for contractors that are employed by Kentucky Power?
Correct.
All right. Are you aware of any other representatives of employees who are currently parties to this case?
No.
Are you aware of any other representatives of employees who have filed a motion or a petition to intervene in the case?
No.
To your knowledge, has IBEW Local 369 intervened in a Public Service Commission case before?
None that I'm aware of, no.
Do you know if any other IBEW local unions in Kentucky have intervened in other Public Service Commission cases?
Yes.
And
IBEW Local 2100, they represent the guys at LG&E. They've done something similar to this.
and how do you know that they
Former
have
Rep
intervened?
Donnie Colson informed me of this. Let me know.
And do you know if the IBEW Local 2100 was permitted by the Public Service Commission to intervene in any of those rate cases?
I believe they were, yes.
Do any of the members of our union reside in Kentucky Power's service area?
Yes.
And you've already testified that, if I understand correctly, that we have somewhere between 375 and 500 members who are employed by contractors that work for Kentucky Power. Is that right?
Correct.
Can you explain why the union, IBEW Local 369, wants to intervene in this case?
I guess the main reason that I would believe that we would like to be an intervening party would be that to represent the employees, to make sure that they've got a voice in this process, to represent the employees that we represent. So,
the employees that work for these contractors, including the electrical contractors and the tree trimmers, do you know where the money comes from to pay for these contractors to work for Kentucky Power?
well, I guess ultimately it comes from Kentucky Power, the utilities.
And what's your experience with market rate for linemen in Kentucky? For wages for linemen in Kentucky?
It's competitive, but where we run into an issue, especially in Kentucky, on the line side, it's hard to get. There's a glut in the market as far as skilled trades go, in all skilled trades, but especially in the line side of it. Keeping and retaining and trying to get people to work in this area, it's very tough because everybody wants to go and chase the big money other places. So it's hard to compete and keep those kind of workers that we need here.
Thank you. I don't have any further questions at this time.
Mr. Overstreet?
No questions, Your Honor.
Mr. Chandler?
Not at this time.
Mr. Kurtz?
No questions.
Staff?
Good afternoon. Is IBEW Local 369 itself a customer of Kentucky Power?
No, ma'am.
And you can you confirm for us that IBEW Local 369 is representing only the contractors for Kentucky Power that these employees are working for?
Correct. Yes.
IBEW is not representing those contractors, only the employees themselves.
Right. There's an IBEW group that represents, I think, like meter readers at one of the AEP lots down, I think, in Pikeville. But that's a different IBEW. It's not us. We represent solely like subcontractors, like your Wright Tree Services, your Asplin Tree Services, your Par Electrics. I'm trying to think of some other ones, but yeah.
I'm just trying to clarify, when you sit there and say you represent those companies, those contractors, that you're actually representing the employees of
Correct.
those
Correct. I
contractors.
apologize. We represent the men, not the contractor itself.
In the motion to intervene, IBEW Local 369 states it has an interest in the safety, quality of service, and rates charged by Kentucky Power. Can you give us a little more explanation of what specifically your special interest is in this rate case?
Well, absolutely. Like I was saying earlier, we want to ensure that the workers' voice is heard through this process as well, and we represent those workers. It's a very demanding and I want to. It's a dangerous job too, as well. I mean, just recently we had a guy call, 95-degree weather, and they're walking 2 miles up a mountaintop to clear brush for line work. We represent those guys, and we want to ensure that their voice is heard through this process, I guess, so to speak.
Okay, I guess in a little further follow-up, stating that you have an interest in the safety of the services provided by Kentucky Power, how are those safety issues related to the issues presented in this rate case?
I've never been involved in an intervening process, so I don't know the exact answer. I guess my thought process is if rates were decreased, or if rates weren't increased, or if or whatever, that we want to ensure that we've got the manpower that are available to work there. We want to make sure that they've got quality equipment, and our contractors can bid and be competitive when they bid these jobs. If not, we lose out on that manpower and the knowledge base that's there for those people that are working on that on those lines. And it becomes a safety issue when you get less skilled workers, I guess, so to speak.
And IBEW states in its motion it has an interest in the rates charged to consumers because many of its members live in areas served by Kentucky Power. Is it IBEW's position that no other party can adequately represent its special interest?
Yes, true.
The Attorney General of Kentucky has statutory right to intervene in commission proceedings to protect consumers' interests. Could you explain why the Attorney General in this rate case could not adequately represent IBEW's special interests?
I guess because we know the electrical industry, and we could offer valuable input where that comes up.
If IBEW were permitted to intervene, as you just mentioned, there might be some valuable input from an electrical industry standpoint, but do you have any plans of how you would particularly assist the commission in fully considering this issue?
Not at this time. I couldn't answer that.
And you said IBEW Local 369 has never previously intervened in a case before the commission?
Not that I'm aware of, no.
As you've been sitting here today, you've heard some testimony from other entities, correct? Were you aware that discovery and expert testimony is often part of these proceedings?
Not until sitting in here today.
Okay. Can you give us any idea as to whether IBEW would be participating in those processes?
Could you repeat that? I'm sorry.
Sure. I'm talking about the discovery processes that are often undertaken in these cases, as well as providing expert testimony. Would IBEW be participating in those capacities?
We would be prepared to provide expert testimony, yes.
Can you confirm whether any Kentucky Power employees are members of IBEW Local 369?
There are none.
No further questions from staff at this time.
Commissioner Cicero, questions?
You mentioned one of the primary concerns was safety of the contract employees, and I believe those contract employees are subject to the same safety regulations that Kentucky Power subjects their own employees to. Is that correct?
Yes, I believe so.
So if we look at the being equal on that basis, then anything outside of that would be contract negotiated between the contractor and Kentucky Power, wouldn't it?
Correct.
Which really wouldn't have anything to do with the rate case, would it?
Not sure.
No further questions.
Commissioner Matthews?
I have none.
I have no questions. Counsel, anything direct?
Yes, briefly. Mr. Devine, you testified that some of the members of the union do live in Kentucky Power's service area. Is that right?
Correct.
But does the union represent consumers or employees?
We represent consumers. We represent employees that do work on Kentucky Power who are also consumers.
Right. And the union itself, though, every person consumes services, power generally, whether or not they're a member of a labor union. Is that right?
Correct.
But the union's special interest is not about people just as consumers. Is that right? It's about them, their wages, hours, and terms and conditions of employment. Is that correct?
Yes.
And there are a number of questions in regards to safety. Is the our jobs that are, in general, our jobs that are fully staffed, in your opinion, more safe or less safe than jobs that are understaffed?
More safe.
And when employees are provided state-of-the-art equipment versus older equipment, is it generally more safe to have state-of-the-art equipment or older equipment?
More safe with newer equipment, yes.
And is the staffing and provision of equipment, I mean, that is dependent in some respects on the amount of money that is budgeted for a contractor to perform that work. Is that right?
I would believe so, yes.
All right. Thank you. I don't have any more questions at this time.
No question, Sean.
Mr. Chandler?
Just quickly, I just want to make a statement that per our statutory standard, that the AG is willing to represent the customers, all customers, as it pertains to the rates and service, as members of the broader residential class.
Mr. Perkins?
No question.
Staff? Commissioners? You may step down and be excused. Counsel, would you like to make a short summation?
Thank you. Yes. Essentially, the IBW's special interest in this case is it's the only party that is attempting to intervene that represents employees. And while we do not represent employees directly of Kentucky Power, we do represent electrical contractors who are employed by Kentucky Power to do work on distribution to do work on the power lines. And we also represent tree trimmers, line clearance tree trimmers, whose job it is to cut trees and brush to make sure that they're clear of the line. So the employees have a direct interest in Kentucky Power's ability to continue hiring these contractors. Of course, some of these contractors are in business because Kentucky Power is in business, and if Kentucky Power didn't employ these companies to perform the services on the power lines or the line clearance tree trimming, the contractors may not be in business, and neither our members wouldn't have jobs. And we also believe that the ability of Kentucky Power to have to pay competitive contracts to these contractors and these contractors to bid for this work competitively at with market wages and benefits is an interest of the union. As Mr. DeVan testified, we sometimes have difficulty keeping quality linemen and women in Kentucky because they're able to earn higher wages in other states. And so we certainly have an interest in making sure that Kentucky Power has competitive contracts with these contractors who then can provide competitive wages, benefits, and safe working conditions. And that's our concern, and that's why we're asked to intervene in this case. Thank you.
Mr. Basil, you may be excused or you may stay, as we've told everyone else, for the rest of the proceeding. It's up to you.
Thank you, Your Honor.
Thank you. All right, is Walmart ready to go?
We are, Commissioner.
Okay, well, if you would please come forward, counsel, identify yourselves and your witness, then we'll proceed.
Your Honor, I'm Don Parker, and I'm here for Walmart. I have with me an attorney in my office. His name is Barry Nome. He's not making an appearance today, but he's assisting me for the hearing. Our witness is Greg Tillman. He works for Walmart.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
I do.
And you may be seated. Counsel, you may ask.
Thanks, Commissioner. Mr. Tillman, can you give us your full name, please?
Is this on?
It is, I think.
Okay, it's red.
You're loud
We
enough.
hope it's on.
I want to see green lights.
It's loud enough.
My name is Gregory W. Tillman.
And what do you do, Mr. Tillman?
I work for Walmart as senior manager of regulatory analysis.
And tell me what you do in that position.
Basically, what you see here is what I do. For the most part, deal with regulated utility rates in intervening in cases and identifying where those rates can be improved in terms of Walmart's business. Also do a whole lot of rate analysis in terms of determining whether or not rates are conducive for things like renewable generation, for alternative generation, for opportunities that Walmart has for energy efficiency projects, and how those impact Walmart from an economic standpoint.
Now, the things that you just described that you do for Walmart, is there a particular geographic area that you do it for, or do you do it everywhere?
I do it basically across the nation. U.S. and Puerto Rico our group represents. We don't do a lot in Puerto Rico because there's not much you really can do there, but we do across the nation pretty much in any jurisdiction.
How long have you personally done that job?
I've done it at Walmart. I've been at Walmart for just over 18 months now.
Tell me about your prior experience that allowed you to get this job at Walmart.
I have spent way too many years to count, 23 plus years in the energy industry. Much of that at regulated utilities. I worked for a Public Service Company of Oklahoma shortly after I left the Army for 8 or 9 years, and was in the deregulated energy industry for quite some time. Just prior to Walmart, I worked for Oklahoma Gas and Electric, where I was a manager of pricing and developed programs at OG&E that have gained some notoriety. Our Smart Hours program was very successful in terms of dynamic-based pricing for residential customers.
Did you cause verified testimony to be filed in this case?
Yes.
Do you have a copy of that in front of you today?
I do.
Now, did you prepare this testimony?
Yes, I did.
Once it was prepared, did you edit it yourself?
Yes.
Do you have any corrections to the testimony that you want to make today?
I do not.
If I were to ask you those questions that are on your verified testimony today, would you give me the same answer?
I would.
And do you adopt what was filed as your verified testimony as your direct testimony here today?
Yes, I did.
Anything else on that? Yeah. Okay. Commissioner, we've marked this as Walmart 1, and I understand that the reporter does have a copy of it. My understanding from staff counsel was that you were provided copies of this, but I have additional copies if you want it.
It won't be necessary unless council and staff believes they need a copy. And if
Is Walmart 1 Mr. Tillman's testimony?
Yes, it is.
Yes, we have a copy.
Yeah.
Mr. Shannon, you need a copy. Okay.
Thank you.
Anyone else?
And we ask that Walmart 1 be admitted as its
It will
testimony.
be admitted. Walmart 1 will be admitted as an exhibit to the witness's testimony.
In service of efficiency, I don't have any further questions at this time. I'm sure that others will, and I would ask for the opportunity to do so.
Oh, you'll have the opportunity to redirect.
Just wanted to make sure. Thank you.
Mr. Overstreet, questions?
I have one question, Your Honor. Mr. Tillman, Public Service Oklahoma, is that an AEP company?
It was not when I was there, but after I left, it became an AEP company. It was a part of the CSW companies when I was at employed.
And CSW and AEP merged at...
I'm going to say 98, early 98 or late 97 in that time frame. I'm sorry. Was that your question?
Thank you.
Mr. Chandler, questions?
Just one. If permitted to intervene, does Walmart intend to conduct discovery and provide testimony on certain issues?
As a matter of policy, Walmart doesn't do a lot of discovery, only in cases where we really need to get to an answer about something specific. But yes, we will provide evidence and testimony regarding the issues in the case. Specifically, we'll talk about ROE, revenue allocation, rate design, and maybe some other matters as they impact Walmart in unique ways.
Mr. Kurtz?
Thank you, Your Honor. Just a few questions, Mr. Tillman. Will you turn to page 3 of your testimony?
Yes, sir.
On line 14, you indicate that within Kentucky, Walmart has 30,000, almost 30,000 associates. Is that correct?
That's correct.
How many of those are part-time workers?
I do not know the differentiation between part-time and full-time.
So as far as you know, the majority of this could be part-time workers?
I have no idea how much is part-time, how much is full-time.
Okay. Now, the next sentence, you say Walmart spent $1.3 billion with 848 Kentucky-based suppliers supporting an additional 35,000 jobs. Do you believe that to be an accurate statement?
I believe that to be an accurate statement. Yes, Walmart does a lot of home-based supplier vendor access in United States manufacturing throughout all of the states we do business in.
So you believe that there are 848 Kentucky-based suppliers serving the Kentucky Walmart stores?
I believe that the 848 Kentucky-based suppliers serve more than just the Walmart stores in Kentucky. I believe they provide goods and services for all Walmart stores.
Excuse me, let's interrupt a second. There's some noise like a busy signal or something on a phone. Maybe we can check on that in a second.
Hopefully it's not a fire alarm. I got my water.
I would hope they would go off in this room, too.
Every room but this one?
It was a phone that was.
Okay, I'm sorry for the interruption, but could everybody hear the questions and the answers up to the point where we broke? Okay. Counsel, you may continue.
Yeah, thank you. And I'd like to have marked as an exhibit, KIUC, I guess, cross-examination exhibit 1. This is a document off the Walmart website.
Thanks, sir.
Counsel, take a look at it, and if you have any objections, you may express them prior to the ruling.
Mr. Tillman, are you familiar with this document from the Walmart website?
Yes, it's the reference we use in our testimony.
Okay. So if we turn to page 2 of the document, we see associates in Kentucky, 29,610. At the top.
Yes.
Is that where you got your nearly 30,000 associates in your testimony?
Yes, sir.
Okay. Under suppliers, it says spent with suppliers. Well, first of all, supplier figures, it's footnoted, provided by Dun & Bradstreet for fiscal year 2017. Do you see that?
Yes, sir.
Did you independently review the Dun & Bradstreet report?
I did not.
So basically, Dun & Bradstreet did some analysis. Walmart corporate adopted it, and then you've adopted it as your expert testimony.
Yes.
Okay. We'll ignore the sort of the double hearsay nature of it, but let me ask you these questions: is the 1.3 billion on this document the same 1 point? Is that where you got it in for your testimony?
Yes, sir.
Okay. Number of suppliers, 848. Is that where you got that number from your testimony?
Yes, sir.
Now, on this Walmart corporate report that was taken from Dun & Bradstreet, it doesn't say Kentucky-based. And as I understand it, you never reviewed the Dun & Bradstreet report. So why did you insert Kentucky-based when this report doesn't say that?
These are Kentucky-based suppliers based on the report. We use this report in all of our states, in all of our jurisdictions that we do business in. to provide an analysis of Walmart's impact on the economic of a state.
You haven't reviewed the Dun & Bradstreet
I have
report.
not.
So how do you know that to be a true statement?
Well, I have not verified myself personally that this is the truth. This is the reference that we use to provide the information that we use to support that Walmart is a key player in the economics of any state.
Well, can you name me 5 of these 848 suppliers, or let's make it 10? Can you name 10 of them?
I don't have a list of the suppliers, sir.
Well, if you haven't reviewed the Dun & Bradstreet report, you haven't independently verified it, the Walmart corporate document that you've taken this information from doesn't refer to Kentucky-based. How do we know, then how do you know, how does the commission know that that's a true statement? You can't independently verify it, can you?
I probably could independently verify it with the underlying reports, but I have not done that. What I believe is that Walmart does not provide information that is not the truth on its website.
Well, it doesn't say Kentucky-based on its
Objection.
website.
I think he interrupted the witness before he finished his answer.
I'm sorry, go
So
ahead.
you're asking me why I believe it. I believe it because Walmart doesn't lie about these things. That this is our impact on the state of Kentucky.
It doesn't say Kentucky-based. You've
You are
inserted
correct.
that, right?
You are correct. It
Can-
does
can
not
you-
say
can-
Kentucky-based suppliers, but it is a sheet, a page that is referenced to the state of Kentucky and our impact on the state of Kentucky.
Now, I've reviewed this for other states, and there are similar information, and it never says the specific state. Are you look at this report
Right
all
at the
time,
very
right?
top of the page, it says Kentucky, and then it says associates. Associates in Kentucky, average wage. This is about Kentucky. This information you got here by clicking on a link that was the graphic of the state of Kentucky. So why, I just don't understand why we would put in a link from the state of Kentucky, what would be happening in the Commonwealth, unless it was happening in the Commonwealth.
You may not understand that, but you've not independently
correct.
verified it.
I have not verified it.
Your Honor, I move to strike that sentence from his testimony as having no foundation whatsoever. He hasn't looked at the Dun & Bradstreet report that the corporate cites to. Then he's added the phrase Kentucky-based with no basis, pure speculation.
While I think your motion is well taken, I think the commissioners can consider it for what it's worth, if anything.
Now, Walmart in Kentucky sells Samsung refrigerators and Samsung TVs, correct?
I'm not sure what all the brands we sell, but I believe we do carry Samsung products.
Now, those are all made in South Korea, right?
I'll take your word for it.
I'm just having a problem with, if you can't even name one of these 848 allegedly Kentucky-based suppliers, where does $1.3 billion of sales come from? What suppliers in Kentucky provide $1.3 billion to Walmart? Are you sure this number doesn't include Samsung and Apple that's made in China and all the other Chinese products?
I am not sure exactly what all that, I believe that is going to suppliers that are based in the Commonwealth of Kentucky, and the $1.3 billion is how much Walmart spends with those specific suppliers.
That's what you believe?
That's what I believe.
But you can't verify it? Or you never have verified it?
No, I have not.
Okay. Thank you.
Staff?
Thank you. Excuse me. Good afternoon, Mr. Tillman.
Good afternoon.
Can you tell me what tariffs Walmart takes service from Kentucky Power under?
We take service from the LGS tariff, IGS secondary, IGS primary, and one facility takes
IGS subtransmission.
And tell me if you are aware that tariff IGS includes the secondary, primary, and subtransmission within one tariff.
I am not, I'm not necessarily fully aware of that. I've looked at the tariffs individually, but haven't looked at the tariff book. I've looked at the rates, I should probably say.
Okay, and that's fair. There is one point I want to clarify. I believe there was an inadvertent mistake in the motion to intervene, in which on page 2, I believe, it was said that Walmart takes service under tariffs LGS and QP. And I just want to clarify, or counsel to do that. Tariff QP, just a very brief history, was combined with another tariff into IGS in a previous case.
That was the most recent case, which we were involved in, yes.
The 2012 case, I believe, is when it was combined.
And then 2013 was.
And then in 2014, the tariff was removed from. I just wanted to make sure we clarified that.
Yes, I agree with you.
And you say that you've reviewed these tariffs. Can you confirm that Kentucky Power has proposed rate increases in both tariff LGS and the provisions in tariff IGS that apply to Walmart?
Yes, I can. That from my review, I apologize. I've done a quick review. I haven't done a full analysis. I believe it was in the low teens was the percentage increases, either just for Walmart stores or for the rate in general.
Thank you. Going back to your testimony, I want to confirm that it's your testimony that Walmart has 105 retail centers throughout the state of Kentucky,
That's
correct? Of those 105 retail centers, there are 9 retail centers in Kentucky Power service territory.
That's correct, about 10%.
And if you know, broken up between the larger Walmart discount store, the neighborhood market, a Sam's Club, those are the 3 types of retail stores that would be in Kentucky?
Walmart supercenters and Walmart discount centers are actually different sizes.
Yes, of course.
Supercenters have groceries, and then neighborhood markets and Sam's wholesale clubs. Yes.
And do you happen to know of the 9 retail centers that are served by Kentucky Power what the breakout is?
I apologize, but I don't have that information in front of me. I pull it and I look at it in aggregate, and I look at individual rates, but I don't recall. It seemed like maybe 5 of them were supercenters. And we were actually talking, I couldn't remember if there was a Sam's in there or not, but the rest would be neighborhood markets.
And in your testimony, you referenced that Walmart has 2 distribution centers in Kentucky.
That's correct.
And is it correct that neither of those are served by Kentucky Power?
Neither is served by Kentucky Power.
And then the next question is in regard to the amount of electricity consumed by Walmart's stores served by Kentucky Power.
Right.
Subject to check. Is it correct that Walmart purchased roughly 9.5% of its electric consumption from Kentucky Power? And I should say 9.5% of all electricity it consumes
In the state of
in the state of Kentucky, or by Kentucky suppliers?
Subject to check, I believe that's correct.
In your testimony, you provided testimony as to why Walmart has a unique interest that's not represented by any other party to this case. Just very briefly, could you explain Walmart's position why the Attorney General cannot adequately represent Walmart's interest in this case?
I think the general parts of the case, the revenue requirement, ROE, I think the Attorney General, and this is based basically on my experience with the KU Electric and the LG&E cases, that the Attorney General in general handles those in a way that benefits all of us. But when we get to revenue allocation, and we'll talk specifically about revenue allocation, what happens in revenue allocation is there are many groups of customers, and none of which want any of the revenue assigned to them. So you run into conflicts between what a residential customer should or would want versus a commercial customer or GS customer versus a larger commercial and even into the industrials. And we see examples all the time of the industrials trying to push increases down lower into the food chain, and AG, rightfully so, should represent residentials and try to keep their rates moderate. In that case, well, it all has to go, it gets pushed somewhere. It's the balloon, the proverbial balloon. You push in one place, it's going to go up somewhere else. So, and I don't think, and I wouldn't even expect the AG to turn around and start defending Walmart's interests in the case in terms of revenue allocation. I think they should defend consumer interest, and by consumer I mean residential customers. And even Walmart at times, we have to think about the whole gamut. We have to think about residentials. We have to think about commercials, which is the rates our stores on, and we have to think about our vendors in terms of maybe some industrial rates. We have to take these things into consideration when we take positions on revenue allocation, if you will, or other aspects. And hopefully we come up with our balance, but at the end of the day, what has to happen is we all have to explain our interest and bring our case, and the commissioners take the responsibility of balancing the interests of all the customers and coming up with the best solution for the state at that time. And so while I don't know that I'm opposed to anything about what the AG will do, I would not expect them to represent Walmart's interest. And in fact, I really wouldn't want them to. I want them to represent the interests of the people that they are here to represent. So.
Excuse me. There's another movement in this matter who seeks to intervene, the Kentucky commercial utility customers. Can you give me Walmart's perspective on whether or why not the Kentucky commercial utility customers can represent Walmart's interests?
I'm going to have a real hard problem with, I don't really understand what their positions are in the case or what they would be. But in terms of the customers that they represent, I believe one is a health care provider and the other is a sawmill based on the filing they made in the case. And so when I think about, the commercial group of customers, I think about everything that's not big industrial or not residential. So it's a huge group. And even within that group, we have several rates that apply to us. We have other rates that apply to smaller commercial customers. And so from my perspective, when I think about what they will be representing, while it may overlap some with Walmart's interest in the case, it does not cover the breadth of Walmart's interest in the case. So I believe, from Walmart's perspective, we have to look across all the rates that impact us
And then, like I spoke of earlier, a little bit more than that in terms of people that aren't stores, that we need to be cognizant of their situation. And so when you think about will they or won't they represent what Walmart's about, I don't see how they can do it and still represent their interests specifically.
Let me get a clarification on one thing. When you talked about Walmart considering consumer interests in terms of the residential classes,
That's right.
also its vendors' issues in terms of industrial, because KIUC, the Kentucky Industrial Utility Customers, is an intervener in this matter. Do you have a position, Walmart have a position in regards to KIUC's ability to represent the vendors that you would also be considering?
I believe to the extent that our vendors are included in the KIUC group, they will be represented well by KIUC. Many of our vendors are not big industrials. They're smaller shops. We have farmers throughout the nation that provide produce that is sold in Walmart stores. So to the extent that KIU represents any industrial customer, I believe they will represent them well.
Again, in your testimony, you discussed that Walmart has a unique load profile. Could you expand upon what makes Walmart's load profile so unique?
Well, and unique in terms of what we call commercial customers. Most commercial customers do not operate 24/7, whereas most Walmart facilities do operate 24/7. So we have a much higher load factor than I'd say the average commercial customer. And in most cases throughout the nation, we have a higher load factor than customers that are on the same rates that we are, in the same rate classes.
And my last question, excuse me, I believe that you've answered
Either
in
that or
part.
you're going to need some water.
I do. I'm about ready to do it. If Walmart is permitted to intervene, how would Walmart assist the commission in fully considering this matter?
Every time Walmart is an active party in a case, we do our best to bring the right evidence about the issues we have. And we provide that evidence to the commission, and we believe the commission will make the right decisions for the Commonwealth in this case, for the state in which they're making those decisions. So Walmart attempts in every case to provide information that assists the commission. We make it a policy not to do anything that would disrupt proceedings. And the question about discovery, we don't do a lot of discovery because if it's not necessary, why would you want to bog someone down with it? And that's not to say that we just don't get so deep to require a bunch of discovery. When we need it, we ask it, we're done. And when we participate in settlement, we're there to look for the result that works with all of us. We make compromise as we hope and expect others to make those same compromises. So we believe we support commissions in every case that we're involved in.
Staff has no further questions.
Commissioner Cicero, questions?
Your testimony seems to imply that because of the economic benefit to Kentucky, that Walmart should enjoy possibly some favorable position in being an intervener. And in fact, you state it's a single customer with a large volume and multiple locations, which makes it kind of unique. And I would challenge you that there's other locations that are probably very similar if you took like a Kroger.
Correct.
And in the LG&E and the KU case, you intervened.
Yes, sir.
Did you provide any type of testimony or basis for the rate determination in that case?
If my recollection's correct, we were not opposed to the rate design that the company laid out in its direct case. So we wouldn't have done a whole lot of rate design testimony changes, things like that. But we, if I recall correctly, we supported the company's rate design proposals.
So following back up on the last answer you gave to staff, you made the statement that you believe that the commission would look at all parties fairly and make a determination based on all the evidence presented on a fair allocation to all classes. I think that's paraphrasing, is that?
That's fair. I believe that.
So from that perspective, I'm not sure what the basis is that Walmart is saying that the commission, in reviewing the evidence, what gives it that unique perspective? Is there something else you can add that says Walmart, because of X, needs to be elevated somewhere beyond the Attorney General or any other commercial, and I don't mean elevated, I mean given the same.
Right. And why should Walmart be a full party in the case?
Right.
And I believe that we do bring specific evidence that concerns itself with that large national retailer position in terms of allowing the commission to have the evidence to review that would put them in a position to balance our interests amongst all customers' interests fairly across the entire proposal.
I'll let it go at that.
Mr. Matthews, questions?
I have none.
I have none. Mr. Parker, any follow-up?
We do, Your Honor. Mr. Tillman, I think you had mentioned that there are a little bit shy of 30,000 associates that work at Walmarts in Kentucky. Of those, do you have an estimate as to how many associates work at the 9 stores within the footprint that's in question here?
I think the average per store is probably going to be around 300 associates. So that would be somewhere between 2,500 and 3,000.
And you're not sure on the mix between full-time and part-time employees in that?
I'm not. I'm not. But, you know, when you think about full-time versus part-time, you think, some people, they work part-time. They want to work part-time. And so there's jobs for them. And some people want to work full-time. It doesn't make the job any less important for that person or for the Commonwealth of Kentucky.
The data sheet that was admitted as, I think, cross-examined exhibit number 1 from KIUC. You're familiar with this data, correct?
Yes.
Now, I think you mentioned that you've relied upon it before. Is that correct?
Yes, we do.
Could you explain that a little bit better?
Well, essentially, in every state, in every jurisdiction that we testify in, we think it important that Walmart's impact on the economy is understood by the companies that serve us and by the commissions that represent us. So yes, we use this information pretty much across the board to define who Walmart is in that particular jurisdiction.
So you have in the past relied upon this similar data in other states, is that correct?
Yes.
So let's say North Carolina. Have you looked at the North Carolina data before?
Personally, no, but if you move south a little bit, I could say yes.
How about Arkansas?
Arkansas, yes. South Carolina.
And so is the state-specific data data that you have relied upon when you testified in those other states?
Yes.
Now, if somebody were to ask you to go do a more detailed investigation as to the reliability of the data, could you do that?
I could.
And specifically, what would you do if somebody asked you to go verify the accuracy of the data?
Well, I think I would go to Dun and Bradstreet first and see where they came up with their information, and then I would follow that to the key. But internally in Walmart, we have people that track and monitor and provide this information. Just like when you get down below, how do we know how much community giving we do in a particular state? That has to be tracked at the store level, basically, because that's who's doing most of the community giving across our nation.
So if KIUC actually wanted to know these answers, they could ask you later in this case, couldn't they?
They could.
Now, is it true that Walmart has some aspects of its business that could seem as industrial to the Commission?
And I believe our distribution centers probably fall more into that range, but obviously in this case we don't have any distribution centers. But in Kentucky Power in general, we do have some of our stores that fall on what would be considered industrial rates, the IGS secondary, IGS subtransmission, IGS primary rates.
So if the evidence and testimony that's elicited from KIUC goes in one direction and the position taken by the Attorney General's office goes in another direction, what would Walmart do in that situation?
In terms of distinguishing between...
Well, how Walmart is specifically affected by those different directions that they're going?
Well, I think it's like I said before about the balloons. So that's got to go up somewhere. And traditionally in our business, that's always been forced onto the commercials in the middle. Walmart as a policy advocates for cost responsibility in rates and in rate distribution and rate allocation, revenue allocation. So what you'll see Walmart do is advocate based on everything else in the case, what is the right place and how is revenue allocation properly done? How is rate design properly done that doesn't drive costs onto customers who should not be paying those costs?
So circling back to that, though, what we just covered, so if the KIUC presents a position that, let's call it A, just to take as an example, but the Attorney General presents a different position, which is position C, I think what you're describing is that Walmart would take a B position, somewhere in the middle. Is that fair?
Well, I would guess that, but I don't know what positions they're taking. But I would expect that KIUC would take a position that would reduce the impact on its customers.
The industrial customers.
That's what they should do, right?
And you'd expect the same thing from
AG
AT.
from residential. And so either one of those positions has got to push those costs somewhere else. So Walmart's position as a matter of how we, what we believe
is what should drive it is the underlying costs, causation, and what is the fair allocation across all classes. And so that's where I believe you would see our testimony go.
But without Walmart's testimony, without the evidence from Walmart, is that position, in your view, going to be fairly represented in this case?
Assuming that those are the only other, if I'm an intervener and they're the only other two, I would guess no, that evidence would not be presented. But that's just a guess. I don't know what they would present overall.
Now, would it be fair to say that one of the virtues of the testimony, the evidence that you can present, is that you bring a national perspective?
I think that's fair to say.
I have no further questions. Thanks.
Before I ask Mr. Overstreet if he has questions, I'm not sure we actually ordered this to be introduced, but now, unless you want to withdraw it, I would have it introduced as KIUC Cross-Examination Exhibit 1.
Thank you, Your Honor.
Okay. Let it be so marked and entered. Mr. Overstreet?
No questions, Your Honor.
Just a couple of questions.
Mr. Curtis, questions? Oh, I'm sorry. You have two questions.
Excuse me, yeah. Just a couple. Mr. Stillman, did you mention that you'd previously been involved as a representative of Walmart in a rate case in front of this commission?
Yes, the KU Electric and the Louisville Gas and Electric case.
And are those the only cases you've been involved in front of this commission?
In Kentucky, yes.
And so, is it true that that Walmart and you on behalf of Walmart have never been involved in a case in front of this commission without the Attorney General, without the, let me rephrase it, excuse me, that you are not aware of cases in this jurisdiction or been involved in any matter where Walmart did not provide cost of service testimony, but the AG has?
I am not aware. We've been involved in, I believe, 2 other Kentucky Power cases. I'm going to say that. A total of 2 Kentucky Power cases prior to this one, and 2 LG&E and 2 KU Electric. So somewhere in those cases, and I'm not aware of who provided cost of service and who didn't in those cases, but now I've forgotten the question.
Well, so from your perspective, it was, I guess the question is, would you agree that you're speculating on the possible impact on commercial customers or Walmart without Walmart in a case pursuant to the positions of KIUC and with the Attorney General's involvement?
Yes, I am speculating that the pressure from either end would probably show up as I don't know, allocations to the commercial customers that would otherwise not, happen if we had interveners for the gamut of customer interests.
And are you aware of the statute in which the Attorney General is obligated to represent customers in front of the Public Service Commission and other boards and state organizations regarding rates?
I'm aware of statute that requires them to represent consumers, which I'm not sure what the relationship from a consumer to customer is, but I'm aware of the consumer statute.
And are you aware of anything in that statute that differentiates between different classes of customers in which the Attorney General is obligated to represent?
No, I'm not. And I'm not aware of the definition of what consumer is in that statute, but I'm trying to get the drift of your question, but they represent consumers, and in some states, consumers specifically means residential customers.
But are you aware?
I don't know about Kentucky.
Are you aware of that definition in Kentucky?
I am not.
That's all I have, Chairman.
Mr. Chairman, just a couple of follow-ups very quickly. Of these 30,000 part-time and full-time employees in the state of Kentucky, Are you familiar with the numerous studies that well, let me ask you this. Have you done a calculation as to how many jobs Walmart took over that were pre-existing? For example, the Ace Hardware store, the local family grocery store, and so forth. How many jobs were taken away by virtue of Walmart coming in?
No.
Okay. Because people only need so many TV sets and so many tennis shoes. If they don't buy it from you, they'll buy it from someone else. And oftentimes that someone else goes out of business when Walmart moves in.
I don't know that.
Okay. Now, let's assume this $1.3 billion of local Kentucky sale goods is correct. I understood you to say that one of these 848 vendors might be a farmer, for example. That would count as one of the 848.
I believe Walmart buys a lot of produce from local farmers.
Now, if Walmart didn't sell the local produce, tomatoes, whatever it might be, those local produce would be sold by someone else to someone in Kentucky. Isn't that right?
Commissioner, I'm going to object on relevance. We're getting really far afield.
Well, yeah, this rules, you may.
Thank you. Isn't it true that those local tomatoes might be sold in Kentucky by someone else?
If Walmart's not selling them?
Yeah.
Is that what your question is?
Yeah.
It's true.
So, in terms of, let me close out by asking you this question. Are you familiar with Toyota Georgetown, Kentucky, the big Toyota plant?
I'm not familiar with it.
Okay, well, about 25 years ago, the state gave I think $125 million incentive to get this facility. It now employs about 8,000 people. That wasn't parasitic in any way. That was all new jobs, all new investment. Would you agree?
I can't agree or disagree. I'm not familiar with the situation at all.
Okay. Do you know, in your experience, why states fiercely compete for new industrial manufacturing facilities and give discount rates like Kentucky Power did for this aluminum facility? Whereas commercial customers, because if Walmart comes in and Kmart goes out, the same economic development dollars are not available.
Can you ask the question again?
Yeah,
I'm
why
not
do
sure I heard the
states
question.
give economic development dollars to get industrial customers but not commercial customers? Do you know why?
I think states support their economies with that. I don't know why they choose to give it to one over the other, but I assume at the end of the day it's because it's to support development of the economy within the state. And Walmart is a part of that economy, because without, and it doesn't have to be Walmart, it's any retail provider, right? If you're going to have people in the state, they need to be supported with the provision of goods and services through retail providers, and that's what Walmart does. Walmart has competed in that since I was born, 1962, right? And they've done well, and they've been an active participant in those same communities that the states are providing economic benefit to drive that economy. So I don't know where Walmart became a bad guy for doing its job the best it can, but we support the economy in those states just like anybody else does.
Well, I'm not trying to say Walmart's a bad guy. My only point is that these 30,000 jobs are not incremental. They took away jobs from somebody else. At least one, you would agree, right? Even if you don't know the exact number.
I don't know who they took jobs away from. Walmart provides employment to almost 30,000 people in the Commonwealth of Kentucky. That's what I know.
And you don't know that. Well, we'll leave it. I think we're good on this record. Thank you, sir.
Counsel?
Just a very few questions. When we talked earlier about the Kentucky commercial utility customers, I'm just going to call them KUC, KCUC.
Okay.
Is that acceptable? Will you understand what I mean?
That's the acronym for the group?
With the acronym for the group, and we're not talking about KIUC, but KCUC.
Okay.
One of the entities that KCUC states it would represent if it was permitted to intervene in this matter is Appalachian Regional Healthcare, which has 6 hospitals in the Kentucky Power footprint. Given the argument that Walmart's unique load characteristic derives primarily from a 24-hour-a-day operation, can you help me to distinguish between, say, a Walmart load characteristics and potentially a hospitals, 6 hospitals?
I really can't, and when I was at PSO, I worked with hospitals a lot. They essentially have a relatively high load factor, not typically as high as Walmart. They do a lot of they're open 24/7, but a lot of activity happens from that 6 a.m. to 2 p.m. time period. This was a long time ago, so it may be different, but in essence, they had pretty peaky load, if you know it, high load during that time period, and then it was pretty normalized, smaller after that. Walmart, in fact, has basically high load 24/7, so a little bit of difference in how that load interacts with the rates and the rate design that's presented by the companies.
And you've distinguished that the Walmart's load profile is unique from other retailers, and talking about why, partly is size. Can you say, is that also true, would you say, about Walmart's load profile from other commercial users in Kentucky Power service area?
And again, commercial users, it's a big group of customers. Some, and in fact, when I was at OG&E and talk about, there were commercial customers that, basically had something that ran for an hour or 2 hours per day, and the rest of the time they were sitting at zero. To customers that operate 24/7 and have load factors up in the 80% range. So there's a big difference between that size and shape and characteristics of all commercial customers. So it's hard for me to say commercial customer and know what I'm talking about is how I'm going to say it, because you have to know the characteristics of that load within the framework of the rates that are being applied to that load. So that I'm not sure. I'm not sure how to answer the question in terms of Kentucky Power, but it's been my experience that they across the board, and when you get too many of those kinds of different customers onto a single rate class, you're inviting issues with subsidies and rate design issues, because you can't make the rate itself apply to a hugely different or heterogeneous set of customers. And that's why you see a lot of utilities breaking customers down into much smaller sets and creating classes around those.
And I recognize you may not be familiar with all of Kentucky Power's tariffs, but perhaps from that example from the SGS, MGS, LGS, all having to do with small, medium, large users, and then IUS would be more typical with what you're discussing, it sounds like.
Right, yeah, breaking them down and assigning, and actually classifying separate classes of customer that then get their own revenue allocation based on the cost causation within that particular class.
And I do want to note here that Kentucky Power has proposed to combine two of those rates, SGS and MGS.
SGS and MGS, correct.
Yes.
Thank you.
Staff has no further questions.
Commissioner Cicero?
I have no questions.
Commissioner Matthews?
I have none.
I have none. Mr. Parker, any redirect?
None, Your Honor, we're ready.
Thank you so much.
You may stand down, you may be excused. Mr. Parker, you may provide a summary if you like.
Yes, Commissioner, Walmart's participated in prior cases. We've been active parties in those prior cases. We've provided expert witnesses to testify in the context of those cases. Our goal has always been to attempt to assist the Commission. We want to do that here. We understand the concerns about the proceedings getting more complicated the more parties get involved. We get that. And we don't intend to complicate things. It's just that there is a voice that we feel needs to be heard. We do have a unique interest. You've already heard about the size of our operations here. The unique load profile, the energy consumption, the multiple rates that we're subject to, it's a different perspective, frankly. And we're asking that you let us come give it to you, give you that perspective, because it might otherwise not be heard. Anything else?
Okay, thank you. Appreciate it. You may be excused, counsel, or you may wait till the end, and it's up to you.
Chairman, I'd like to move to take a small recess, maybe 5 or 10 minutes.
Okay, that's fine. Let's go into recess until 25 to 2. A witness for one of the movements, Riverside Generating Company, LLC, has a flight to catch this afternoon, and Commissioner Cicero will have to leave by 3 o'clock. So with the concurrence of all counsel and the parties, we've sort of skipped over and will take next Riverside Generating Company, LLC. Mr. Sanford, will you introduce yourself, any co-counsel, and your witness?
Good afternoon, Your Honor. David Sanford with the law firm of Goff Sanford PLLC in Lexington, Kentucky, on behalf of Riverside Generating Company, and our witness today is Mr. George Sansky.
Okay.
Sir,
Excuse me, Your
Honor, I didn't mean to interrupt you.
Oh, go ahead.
I was going to just note that my partner, Ken Gish, is here, and I failed to announce him at the beginning of
Oh,
the
thank you,
hearing.
Mr. Gish. The only other person I've ever seen do that, other than me forget staff, was Mr. Chandler. He forgot his supervisor, but he's still here. He's still working. Good, okay.
I'm on probation now.
Okay. Sir, would you please stand? Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated, and Mr. Sanford, you may ask.
Thank you, Your Honor. Let's just begin. If you don't mind, please state your full name.
George Stanley Sansky, Jr.
Okay, then, Mr. Sansky, who are you employed by and in what capacity?
I'm employed by Ellis Power Development. I serve as the asset manager for the Riverside Generating Facility.
Okay, and so if you could explain, please, the relationship between LS Power Development and the movement in this case, which is Riverside Generating.
Okay. Ellis Power Development is owner and manager of Riverside Generating Company. Again, I serve as the asset manager for the Riverside Generating Company in Kentucky.
Okay, and what is, if you could please describe the facilities that Riverside has in Kentucky Power Service territory?
Riverside Generating Company has a 2-facility site. Consists of a 3-unit Zelda, approximately 500 megawatts, and a 2-unit Foothills, approximately 330 megawatts. Again, located in eastern Kentucky, outside of Catlettsburg.
Okay, and historically speaking, what is the tariff or the schedules of tariffs that Riverside Generating takes power from Kentucky Power Company?
Riverside Generating takes power from retail service from Kentucky Power under the non-utility generator tariff. The rates are have been set by Kentucky Power as the rates in the industrial general service tariff. So the Riverside Generating Facility, again, since it's consisted of those 2 sites, takes power from under 2 separate meters into the Riverside Generating Facility under that tariff.
Okay, and this is an important point, but Riverside is actually taking power pursuant to a retail tariff. It's not a wholesale tariff, correct?
That's true. It's a retail tariff.
Okay, are you familiar with the proposed tariff revisions that have been filed in the record of this case by Kentucky Power Company?
I'm partially aware of the proposed tariff changes by Kentucky Power. I've specifically focused on those provisions that relate to and would otherwise affect a Riverside Generating Company.
Okay, and what is the tariff, I think you mentioned it earlier, but what is the tariff particularly that is most pertinent to Riverside's interest?
It's the non-utility generator tariff.
Okay, and, I'm sorry, go ahead.
And it's the provisions of the tariff that deal with the applicability of net metering to the Riverside Generating Facility.
Okay, and so can you please elaborate on what are the special interests that Riverside has in this proceeding in relation to tariff NUG?
As I understand it, based upon my review of the Kentucky Power tariff, we may be the only non-utility generator in the state of Kentucky that's taking power under this tariff. And as a facility that's taking power under the tariff and one that has specific interests in the provisions that Kentucky Power proposes to change, we have a special and specific interest. And as an asset manager for Riverside, I have a duty to address my concerns or raise my concerns with respect to the proposed changes.
So as a non-utility generator, Riverside is really in a class of its own. It's not a traditional industrial customer, correct?
That's true. We take power from two separate lines into Riverside, one for Zelda and one for Foothills. We use it for station service and backfeed load. Under circumstances where the plant is running, again, we take power from ourselves. We're self-generating power during times when we're in service.
And you're certainly not a residential customer.
Certainly not a
Not
residential.
really a commercial customer either.
That's correct.
Is it really possible, well, let me ask first off, are you familiar with at least generally familiar with the other parties who sought to intervene in this proceeding?
Generally familiar, yes.
Based upon your knowledge and belief, is there really any of those entities that would be able to represent your interest with regard to this specific tariff NUG?
I believe no. Again, because our interest in this is specific to the proposed language that Kentucky Power proposes to change, and understanding that the other parties are more primarily focused on rates, and that's certainly less of a concern. Again, our concern is specifically focused to the language that Kentucky Power proposes to change, which will now and potentially in the future have an effect on the applicability of the PJM open access tariff to our qualification for net metering.
And for the Commission's benefit, explain why is that a significant concern who this tariff applies to?
Well, it's a specific. It should be a concern because again, we're a retail customer in the Kentucky Power service area. The provision that's being proposed to change would affect us. To the extent that there are other generators that we're not aware of, it could potentially affect them. It would affect other generators on a going forward basis if the changes proposed are made effective.
Is it your belief that Riverside would be able to present issues and to help develop facts that assist the Commission in fully considering this case, particularly with regard to tariff NUG?
I think definitely so. Again, understanding that we may be the only non-utility generator taking retail service under that tariff, I think we're uniquely positioned to provide information related to our dealings with Kentucky Power, how those specific provisions would apply to non-utility generators in Kentucky Power.
And so would Riverside's intervention in this case unduly complicate or disrupt the proceedings, in your opinion?
No, not at all. I mean, I think potentially the contrary. We would help inform the issues, would help inform the understanding of the consequences of the proposed changes to the tariff.
Let me ask a couple of questions. First off, are you familiar with the response that Kentucky Power filed in opposition to the motion to intervene that was filed by Riverside?
Partially, yes.
And there was, I think, some concern there about some information may being disclosed by Kentucky Power in the course of this rate proceeding that it could deem to be competitive information, for lack of a better term. Are you familiar with that concern?
Yes, I am.
Does Riverside have any interest in obtaining information that would be competitively valuable from Kentucky Power in this proceeding?
No, we have no interest in that sort of information. Again, our interest is focused on the issues related to the changes to the provisions in the tariff that Kentucky Power has proposed, and it's not, our concerns are not related to the revenue requirements or the other areas of the tariff.
And so to the extent that Riverside was allowed to intervene in the case and there was a confidentiality agreement in place between it and Kentucky Power, it would be okay if certain information was not required to be produced by Kentucky Power?
Yes, that would be acceptable.
Now, the other part of Kentucky Power's response and opposition had to do with a commercial dispute, maybe dispute's not the right term, a negotiation that's been ongoing for several months between the parties. Are you generally familiar with that?
Yes.
Can you please describe what's really the main issue in that commercial dispute?
Yes, like I said, I'm the asset manager for Riverside Generating. I came on as asset manager in 2016. One of the things we do as a normal course is review our various commercial arrangements. We've reviewed our arrangement with Kentucky Power, and we came to the conclusion that we qualified for the net metering provisions that are contained within the non-utility generator tariff. As a consequence, we notified, entered into discussions initially, and then formally notified Kentucky Power of our interpretation of those provisions of the tariff, and have really to this point been waiting for a response.
Okay, and so the question there, I think, is it's really a factual question as to whether or not Riverside qualifies under the terms of the tariff as it's currently written.
That's right, yeah.
In the course of this proceeding, has Riverside learned that Kentucky Power is actually changing the terms of the tariff in such a way that it's sort of doing in round around that dispute?
That's partly our concern, yes. I mean, our discussions and our formal notice to Kentucky Power came well before the proposed changes to the tariff. We believe we understand and are correctly interpreting the current tariff. It's unclear to us what Kentucky Power is hoping to accomplish in the changes that they've proposed, or how those changes may affect Kentucky or Riverside Generating's business on a going forward basis.
And so is it Riverside's concern that Kentucky Power may be, in effect, sort of changing the rules of the game in the midst of a commercial negotiation as part of this tariff filing?
That's the concern, yes.
And did Riverside have any advanced knowledge of the proposed change in this particular tariff in UG prior to the filing of this rate application?
No, we did not.
And is it your understanding that Kentucky Power represented to this commission that there were no customers who are currently taking power pursuant to NUG, the tariff NUG, as part of its application?
Yes, that was my read of their language.
Your Honor, I tender the witness for cross-examination.
Mr. Overstreet?
Thank you, Your Honor. I guess, first of all, Riverside is a competitor of Kentucky Power because, like Kentucky Power, it sells energy into the wholesale market. Is that correct?
Riverside Generating does sell energy into PJM, that's correct.
Just like Kentucky Power?
I'm not all that familiar with Kentucky Power's business, but I would believe so.
Right. And information likely to be produced in this case concerning Kentucky Power's cost curves and its cost of producing energy would be valuable to Riverside as a competitor of Kentucky Power, would it not?
Riverside's not seeking any of that sort of information in its motion to intervene.
But my question was, it would be valuable.
It could potentially be valuable if that information was given over to Riverside.
So you understand Kentucky Power's concern about providing such information to a competitor?
Yes.
And this commercial dispute, you indicated that it involved the ability of Riverside to engage in net metering. Did I understand that correctly?
That's correct.
Could you point me or the commission to anything in the tariff NUG that even mentions the term net metering, or contemplates net metering?
I think the provision in question provides for net metering.
But what, could you point me to where that is?
Perhaps if I had a copy of it, I could.
No. Question.
Would you like me to read it, or?
Well, first of all, can you just tell me what part of the tariff it's in?
It's in the part of the tariff that referenced the open access tariff.
Is that
Open
special
access
terms and conditions?
I'm sorry, yes, special terms and conditions.
Okay. Yeah, if you would, please.
Would you like me to read the original version or the as proposed?
Either, but why don't you do the as proposed?
Customers desiring to provide startup and station power from other generation facilities owned by the same individual business entity that are not located on the site of the customer's generator, remote self-supply, shall take service under the terms and conditions contained within the applicable open access transmission tariff as filed with and accepted by FERC.
And so there's nothing in that provision that references net metering or the ability to engage in net metering, is there?
It's my understanding that the reference to open access transmission tariff is the avenue through which that would apply.
And that, but again, the tariff itself, but that open access transmission tariff is a FERC tariff, right?
That's right.
And so
What's filed with FERC.
And as I read that language, and please tell me if you disagree, to take service under the terms and conditions contained in the OAT, a customer must, number one, be under common ownership, right?
No. You asked me to read the as revised version. In your revision, you struck common ownership.
Okay, or owned by the same individual business entity, is that correct?
That's right.
Okay. And number two, the generation must be from a site not located on the site of the customer's generation remote self-supply. Is that correct?
As I understand your question, yes.
Okay. And so the dispute between Kentucky Power, the negotiation between Kentucky Power and Riverside doesn't touch on whether the facilities are owned by the same business entity. Kentucky Power agrees that Riverside owns both the Zelda and, I apologize, Foothills. Is that the other one?
Yes.
That's not the dispute. Is that correct?
Again, it's not clear even that there is a dispute. We filed a letter with Kentucky Power providing our interpretation of the tariff as it currently exists with explanation for why we felt it applied to us. It's unclear how the changes that are being proposed here affect our interpretation now or will affect Riverside Generating Company on a going forward basis.
But the changes deal with striking of the term commonly owned and then the insertion of the terms other in front of generation facilities and then the insertion of the terms owned by the same individual business entity. Is that correct?
That's what the change is proposed to do.
And the portion that deals with that are not located on the site of the customer's generator remote supply, that's unchanged. Is that correct?
Right, that part is not changed.
Okay. The rates that Riverside pays, and this is for startup power, is that correct?
That's right, startup and station service.
Those rates are at tariff IGS rates. Is that correct?
That's right.
And do you know of any other intervener in this case that pays tariff IGS, whose members might pay tariff IGS rates?
There may be, I'm not aware.
Would it be a surprise that the members of KIUC,
No, not at all.
so that would be an entity like Marathon?
Yep. But as I suggested in my comments before, I mean, our focus in this isn't as much the tariff as it is the specific changes to the tariff language that are proposed by Kentucky Power.
And those changes deal with this notion of striking commonly owned and substitution of the language other and then generation facilities remains, and then owned by the same individual business entity. Is that correct?
Yeah, generally. I mean, more specifically, it's to how these provisions, how this language we've interpreted. We apparently have with Kentucky Power a disagreement. Apparently, because again, we haven't received a response to our letter. We apparently have a disagreement with them over how this existing language is interpreted, and we believe we have a firm position on why our interpretation of the existing language is appropriate. Again, it's less clear how Kentucky Power would interpret this now or might interpret this at some future date, how perhaps this might change through the course of the proceedings, or how it might affect Riverside Generating Company at some future date. So again, the concern isn't so much to the specific tariff rates, the rates that we pay under the IGS. It's more specifically to the changes to this language that's proposed by Kentucky Power.
Do you have any reason to believe that KIUC will not vigorously represent the interest of customers paying under tariff IGS?
That may be KUIC's interest, but again, that's not the primary focus. And I'm sure that's not KUIC's primary focus on this language. I mean, again, our primary focus is this language.
Pardon me, I'm sorry, I didn't mean to cut you off. So Riverside's primary focus is the application of a specific provision of a specific tariff to its operations. Is that correct?
To how it receives retail service from Kentucky Power and how it's billed for that service, and its applicability to the open access transmission tariff.
And all that's governed, as I understand your position, by that paragraph you read here earlier in the proposed tariff.
Yeah, that's the provision in the tariff that's of concern to Riverside Generating Company.
That's all I have.
Mr. Chandler?
Just a couple, Chairman. Just to clarify, if granted intervention, does Riverside intend to conduct discovery or provide testimony in regards to the changes to tariff NUG?
Only as it relates to the specific provision.
And does Riverside take under any other state-regulated rates or tariffs other than IGS or NUG, such as a special tariff or a special contract?
No, we take service only under the NUG and pay the tariffs, pay the rates identified in the IGS.
That's all the questions I have.
Mr. Kurtz?
No questions.
Staff?
Yes, I have a few questions. First, for the benefit of our court reporter, could I ask you to spell your last name?
Sure. SCIENSKI.
And now to make sure I pronounce it correctly, Scienski?
Right, yep.
Thank you.
Thank you.
I know we've gone over this. I want to make sure that I understand a few pieces. Currently, is it correct that Riverside takes service from Kentucky Power under two tariffs, tariff NUG and tariff IGS?
Kentucky Power currently takes retail service under the NUG tariff, and the tariff itself specifies that the rates would be otherwise specified. They're otherwise specified by Kentucky Power as being pursuant to the IGS.
Thank you. That cleared that one up. Can you tell me, how long has Riverside been taking service under tariff NUG?
The Zelda site went into service in 2001. The Foothills site went into service in 2002. I am not, again, I've been asset manager since 2016, the beginning of last year. I'm not aware of specifically when, at what point in time, that tariff became effective. I know it's been at least, I think, the last 4 or 5 years. The current contract, I think, was executed maybe 4 or 5 years ago.
And I want to make sure I say this as simplified as possible. I want to make sure that I'm correct in understanding that Riverside's primary issue is, A, the language in the special terms and conditions section of Tariff NUG, specifically the last paragraph. And do you have that in front of you?
Yes, I do. I still have it here.
Okay. It's really, that is the primary interest.
That is correct.
And the reason that is the primary interest is because under this provision, Riverside is able to take service through the FERC OATT.
That's right. It's Riverside Generating Company's interpretation that the language as it exists now provides Riverside Generating Company, because it has 2 generators remotely located, provides it applicability to OATT in a way that allows them to net station service. And there's some concern that with the changes proposed by Kentucky Power, that might not be the case.
Okay. Without delving too deeply into the contract negotiations, has there been a change in interpretation by either Riverside or Kentucky Power that you're aware of?
I think the realization perhaps on the part of Riverside Generating Company that perhaps it has not afforded itself of an opportunity that's existed in the tariff.
And that opportunity is it correct that opportunity is the possibility of participating in net metering under the OATT?
That's correct.
Your Honor, can I have this is maybe a nuance, but I think it'd be helpful. We've been using the term net metering, but I think self-supply may be a more accurate term. The concept isn't really that Riverside's net metering energy as much as it's supplying its own station power from another generation resource. And I don't know if I'm saying that correctly, but I think that nuance would help this conversation make a little more sense.
Oh, yeah, thank you for that explanation. Of course, if anyone wants to keep using net metering, there isn't much we can do. But with that, you may proceed.
I will use remote self-supply because that was going to be one of my next questions. Thank you for clearing that up. Again, without delving into contract negotiations, I want to make sure that I understand that Riverside's issue is more with the changed language in terms of, as proposed, customers desiring to provide startup and station power from other generation facilities owned by the same individual business entity. And it doesn't go to the next segment of that sentence, that are not located on the site of the customer's generator.
That's right. Our concerns are specific to the changes that were proposed by Kentucky Power.
Okay.
Because Riverside, again, Riverside is 2 separate generators, so that part of the position won't change.
And are those separate generators on different parcels of land?
Different parcels of land purchased at different times, constructed at different times. They just happen to be connected via a fence. I mean, there's a fence that disconnects the 2 sites or separates the 2 sites. But they're together, again, separated by the fence.
And again, I very much do not want to beat a dead horse, but it's the nature of the proposed changes in this tariff that ultimately impact the I won't call them a dispute, the current negotiations.
You mean, was your question, was the intent of our motion to intervene an effort to, maybe just read the question.
I can understand why. I want to make sure that I said, Commission staff is not asserting that your intervention is a workaround for a contract dispute. We want to make sure that we understand it's the nature of the proposed changes, and it lines up to a certain degree with the contract dispute. But fundamentally, it is the proposed changes and how they will affect Riverside's ability to be a self-supply.
That's right. I mean, our concerns and our reason for intervening is related to the language that Kentucky Power proposed. Our issues, if we could call them that again, because we've presented our position to Kentucky Power and haven't heard a response preceded or even becoming aware of Kentucky Power's proposed changes. So Kentucky Power's proposed changes came subsequent to our raising the issues with Kentucky Power related to the interpretation of the existing tariff. Our concerns here are that perhaps Kentucky Power is looking to change the tariff in a way that might affect Riverside now or at some future date by changing the specific language related to its applicability to remote self-supply.
And if Riverside were permitted to intervene, how would Riverside assist the Commission in fully considering this matter?
Yeah, again, it's our understanding based upon the documentation submitted by Kentucky Power that we're the only entity taking retail service under the NUG tariff. So for that reason, I think we're uniquely qualified. We've dealt with Kentucky Power for at least 5 years that I'm aware of, and potentially more, and intend to work through whatever differences we have with respect to the issues we have with them now.
Riverside would anticipate filing expert testimony if Riverside were allowed to participate, providing some sort of testimony to assist the Commission in evaluating this case?
We would, yes.
Staff has no more questions at this time.
Mr. Cicero?
Mr. Overstreet referred to a commercial dispute, which I think Ms. Vincel's been following up on. And for my benefit, is it a commercial dispute? Are you in contract negotiations, or is this just strictly language that has to do with the tariff and the fact that you're afraid that there won't be a resolution to that other than through an intervention and a rate proceeding?
If I understand your question correctly, it's more the latter. I mean, the former, to the extent, again, we can call it a dispute, is ongoing. And again, we've provided to Kentucky Power our interpretation of the existing tariff, and we expect that process will play itself out. Our concerns here, our reason for intervening here, are related to the specific changes they've proposed to make to this same tariff that affects the applicability for remote self-supply.
So are there ongoing discussions with Kentucky Power with regard to the tariff itself?
There are not ongoing discussions. Again, we've submitted a letter, I think it was early June, to Kentucky Power where we laid out for them our position as it relates to the interpretation of the tariff and have not heard a response.
So no response whatsoever from Kentucky Power with regard to your concerns?
No, just that the gentleman that I forwarded to suggested he was going to review it with his management and we would hear back.
So there is no contract negotiation or anything similar, commercial discussion or anything else?
Unless you can call the back and forth that we've had up to the point in time where we sent the letter, a negotiation. Again, it was a discussion of the applicability of that specific provision. I think at points in the past we may have had correspondence with Kentucky Power where they asked us to sit down with them or to negotiate a contract. But the discussions we've had related to the applicability for remote self-supply culminated in our issuing the letter to them in June.
I have no other questions.
Commissioner Matthews, questions? I have no questions. Mr. Sanford, anything direct?
Got a few, if you don't mind, Your Honor. And maybe let me go in sort of reverse order, going back to a few questions that the Vice Chairman asked about the commercial dispute. There has in fact been a special contract between Riverside and Kentucky Power, correct?
That's right, yep.
And so, do you know if that special contract's currently in effect, or has it already expired?
It's in effect.
Okay. And so, but it is necessary, it's time, just in sort of the ordinary course of the contract's life, to renegotiate and to reconsider and to basically to remake that contract?
Yeah, that's correct. I mean, again, when I came on board in 2016, and even my predecessor, always looking for opportunities to improve the economics of the project, and having regular contact with our Kentucky Power contacts, have discussed, contemplated re-executing, renegotiating the contract.
Okay. And then there were a couple of points that Mr. Overstreet had raised that I think bear a little bit of clarification. He characterized Riverside as a competitor of Kentucky Power in that I guess you both sell power to PJM on the wholesale market, correct?
That's right.
But you're really not a competitor of Kentucky Power. I mean, Kentucky requires that we have an exclusive certified territories act. You don't have any retail customers in Kentucky, correct?
That's right. We have no retail customers.
And being in PJM, presumably Kentucky Power is selling its power capacity into the market to be able to serve its own load, correct?
Presumably, yes.
And as a merchant generator, you don't have a captive customer base that you sell your power to in PJM, correct?
No, we just sell our energy into the grid.
So to the extent you're going to call yourself a competitor of Kentucky Power, that's really in sort of a generic, broad sense, not in a retail sense, certainly.
In the same sense that anyone else connected to the grid, supplying power into the grid, is a competitor.
And Mr. Overstreet also had several questions regarding the IGS rate. You're not really involved in that concern. That's not the tariff that led to the filing of this motion, correct?
That's right. I mean, I tried my best to make that point, but yeah, that's not our focus.
And Mr. Overstreet's down, or Mr. Kurtz is down there, and he does a yeoman's job every case of presenting those interests, and you would expect everything to carry on in this case that way as well, right?
Right. Yep.
So the tariff, again, it was Kentucky Power who chose to put a proposed tariff amendment into its rate case while it was negotiating with the only customer that takes under that tariff, correct?
That's right, yeah.
You didn't ask for this dispute to be raised in the context of this rate case.
That's right.
You didn't have any advance warning that it was going to be raised in the context of this rate case.
No, we did not.
What would happen if that tariff were made a part of this rate case and it was subject to negotiation by all the other parties who have absolutely no interest in it whatsoever, and you didn't have a seat at that table? Would that seem like a miscarriage of justice?
It would. I wouldn't be doing my job as the asset manager for Riverside Generating if I didn't attempt to intervene to influence that discussion.
Would that seem like a denial of due process?
It would, yeah.
And so I think that's all the questions I have, Your Honor.
Mr. Overstreet?
Yes, thank you, Your Honor. You indicated that you sent a letter to Kentucky Power in June.
Yes.
Would that letter have been dated June 27th and sent to Mr. Ken Borders?
I believe so, yes.
So that's not early June. That's
Yeah,
the end of June.
Yeah, it's June.
And
Sorry.
isn't it true that that letter is in reference to an email from Mr. Borders dated March 17, 2017?
Yes.
Okay. And again, I just want to get you to explain, because I'm having a little difficulty understanding how the proposed language change, which deals with the issue of ownership, whether it's owned by the same entity or expressed as common ownership, has any bearing on these discussions which deal with whether the foothills and the Zelda sites constitute one site and they wouldn't be eligible for remote self-supply, or two sites in which they would arguably be eligible.
Your Honor, I just have to object because I think that question's been asked and answered 4 times.
Well, overruled. You can ask it again.
Well, that's the end of the question.
Okay,
Do you
so you
need
can
me to
ask the question again?
Yes, okay. I can remember.
See, that was my problem.
Could you explain to the Commission how the proposed change in the tariff NUG, which deals with the substitution of getting rid of the term common ownership, commonly owned, and substituting owned by the same individual business entity, has any bearing on the discussions between Riverside and Kentucky Power, which center on whether the Zelda and Foothill sites constitute two sites, as Kentucky Power contends. I mean, one site, as Kentucky Power contends, or two sites, as Riverside contends.
Yeah. I guess first off, I'd say it's not entirely clear to Riverside at this point what Kentucky Power's position is on the letter that Riverside Generating submitted. I mean, as I understand it from Ken's email response to the letter, that he was going to take it under advisement and review it with his management. We haven't gotten a formal response. So I don't know that I would stipulate that Kentucky Power's position on it is solely strictly related to whether there's one site or two sites. And I guess beyond that, given we have a disagreement, or perhaps a disagreement, again, we haven't gotten a response, at least of a difference of opinion perhaps, around how the current language is to be interpreted. It's even more difficult for Riverside Generating to suggest how this new revised language might be interpreted with respect to its current circumstances or any future circumstances.
Of course, we won't know what those future circumstances are until they occur, right?
Right, but we do know we are changing them, and we're changing them in a way that we could potentially envision how, and perhaps Kentucky Power has in proposing the specific language, how changes at Riverside or other non-utility generators might affect its applicability.
But those changes deal with the question of ownership, not whether there's one site or two site. Is that correct?
It deals with the ownership of the two sites.
Thank you. That's all I have.
Anna?
Only a comment insofar, Chairman, that the Attorney General does not anticipate conducting discovery or providing testimony on tariff NUG.
Mr. Kurtz?
No questions.
Staff, anything further?
I have a few questions. We talked about a special contract that's being renegotiated, talked about tariff NUG, for which there are proposed changes, and we've also, what I've heard testimony about is an interpretation of the current tariff NUF. So to help me understand and put into context,
Okay.
how does the special contract relate to tariff NUG? I'm sorry, I misspoke. How does this special contract relate to tariff NUG?
Yeah, the special contract specifies that Riverside will take retail service from Kentucky Power under the NUG tariff, and that the rates will be as specified in the IGS.
So to make sure that I understand, Riverside is taking service from Kentucky Power under tariff NUG, but the applicability right now is subject to a special contract rather than the language of the tariff as it currently exists.
I think the language of the tariff is applicable, and I think the contract specifies such.
Your Honor, again, if I may, I'll offer this as a point of clarification. I don't know if the special contract's actually been filed with the commission or not, but I believe it's only about a 2 or 3 page document, and it basically incorporates by reference the tariff.
Thank you. That's helpful.
Mark, feel free to correct that if that's wrong.
To my knowledge, it's been filed, but,
Okay.
but I haven't looked like this.
And staff does not have any more questions.
Commissioner Cicero?
I have no question.
Commissioner Matthews?
No.
I have none. Anything further?
Nothing, Your Honor.
Then you may be excused.
Thank you.
Mr. Sanford, would you care to provide the commission with a short summary?
Sure, I would love to, and thank you for the opportunity, Your Honor. This is a pretty significant commercial dispute that is out there, because if the tariff does apply to Riverside Generation and they are able to avail themselves of the remote self-supply option, then that would be a significant cost savings to them, and I would imagine probably a significant cost impact to, or revenue impact to Kentucky Power. And so whenever you are looking at a question of a tariff and its applicability, there are always two questions that comes to mind. The first one is, who does it apply to? And then once you determine who it applies to, then the second question is, how does it apply to them? The commercial dispute relates solely to the question of how does the tariff apply to Riverside, the current tariff. How does the tariff apply to them? And there is a bona fide factual dispute as to that. If we are not able to get a satisfactory resolution from the company, we are well aware that we have the ability under KRS Chapter 278-260 to be able to bring that dispute before the Commission, and I suspect we would not hesitate to do so. But the circumstance that we find ourselves in is that Kentucky Power is changing to amend the tariff language that governs the first question. Who does the tariff apply to? We weren't provided with notice of that tariff change. The Commission was told that there were no customers that would be affected, which is not true, and it goes to the very heart of whether or not the tariff would ultimately continue to be applicable to our client. And so the fact that the question of who the tariff applies to has been put in question by Kentucky Power in the course of this rate case is highly important to my client, which is trying at the same time to resolve the separate and distinct but related question of how the tariff would apply to them. So we do not think that there will be an overlap of disputes between the commercial dispute and the rate case. We think that those issues can be treated completely appropriately, and there's no reason that they would not be brought together, except for the fact that Kentucky Power has brought this issue on the Commission's plate. As we all know, once a tariff is brought before the Commission and once notice is given to customers that a tariff can be revised, what the utility has proposed may not be the ultimate version of the tariff that ends up being proposed. And it's entirely possible that through the course of negotiations with other parties, through any other manner of circumstance, that the tariff NUG could change in a way that's even more detrimental to the interest of Riverside. And so that is the interest that we are trying to protect while we're trying to determine how the tariff applies to us. We don't want to let the tariff be amended so that it no longer applies to us and we have our knees chopped out underneath us. So that is our position. We thank you for the opportunity to present it. And one thing we've established today that is the utilities are much more efficient at delivering things than airlines. So we appreciate your indulgence on accommodating us on scheduling. Our witness had a time getting out of New Jersey today, and he's got a flight to catch later this evening. So we appreciate that.
Thank you very much. And Mr. Sanford, you or your client, either one, may choose to stay or leave at your discretion.
Your Honor, can I raise one other point that I don't know whether to be offended or flattered, but we were the only party that I think Kentucky Power responded to in writing, and so technically we still have, I think, a few days to file a reply to their motion. I anticipate that we'll be able to file something tomorrow. Would that be acceptable?
That would be acceptable.
Thank you, Your Honor.
Yes, sir.
Mr. Chairman, as the bench knows, I have a plane to catch as well, so I ask that I can be excused.
You may certainly be excused.
Thank you.
Have a good trip.
Thank you, and for the record, KIUC has no objection to any of the interventions of any of the other potential parties.
Thank you. Okay, staff, we had this issue, I guess, about getting this witness first. Now, if anybody is real hungry or needs to eat, we can take 30, 40 minutes or so if you choose to. So we'll let you make the decision.
Yes, we have two move-ins left to go. Can I compromise and say let's take maybe a 15-minute break and
We're letting you make the decision.
All
So
right.
if you say 15 minutes, that's what we'll do.
let's take a 20-minute break. If anybody really wants to
Give an inch.
you know,
Okay.
anyone wants
It's
a
2:30,
20-minute
so we'll
break?
take a break until 2:50. How's that?
And that gives us anybody who wants to go up and get a snack from the cafe up at the 300 building, which is a little more extensive than what's here in our vending machines. They can get there and back.
Okay. All right, that being the case, we will be in recess until 10 minutes until 3 o'clock. back on the record, and as I understand it, Mr. Chandler and perhaps Mr. Overstreet have something to say.
Just with the departure of Mr. Kurtz, I want to make an appearance on behalf of additional counsel Justin McNeil for the Attorney General's office.
Thank you, Mr. McCain. Mr. Overstreet?
Thank you, Mr. Chairman. I want to clarify a statement I made earlier because I simply misunderstood Mr. Scienski's testimony. There was discussion with counsel for the commission about the existence of a special contract. And my understanding of the term special contract, and it comes from the commission's regulation, 807 KAR 5:0011, is a special contract is something that varies from a tariff. So it's, you have different rates, different terms and conditions of service, that type of situation. And while there is a contract between Kentucky Power and Riverside, it is not filed with the commission because it's not a special contract. It simply says you take service under IGS. And so I wanted to clarify that. And I tried to find Mr. Sanford before he left, and he apparently is gone, but I will pass that on to him also.
Okay, thank you. Everybody was invited to either stay or leave. I said at your discretion. I guess perhaps I should have said at your peril, but anyway, it's okay. Thank you.
And I apologize.
All right, next we have Kentucky Commercial Utility Customers, Inc., is that correct?
Yes, Your Honor. Jim Gardner and Todd Osterloh with Sturgill, Turner, Barker, and Maloney, and we represent Kentucky Commercial Utility Customers, and our witness is Ty Verley.
Okay. You may take the stand, please. Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. Mr. Gardner?
Thank you, Your Honor.
You may ask.
State your name for the record, please.
Ty Vierling.
And Mr. Vierling, how do you spell your last name?
It's V as in Victor, IERLING.
And with whom are you employed?
I work for Harshaw Train.
And in general, what does Harshaw Train do?
We primarily work with clients that own buildings. They own facilities, and we work with them to help them design, build those facilities, operate, sustain those facilities once they occupy them. And then when they use up all their purpose, we help them renovate them.
And how long has Harshaw Train been in business?
Since 1976.
Approximately how many employees?
Just shy of 300. It's about 290.
And where are its locations?
Our headquarters are in Louisville, Kentucky. We also have offices in Lexington, Kentucky. We have an office in Bowling Green, Kentucky. We have an office on post at Fort Knox. We have a service depot in Calvert City, Kentucky. And then we also have an office in Evansville, Indiana.
Who are Harshaw Train's typical clients?
Primarily commercial and industrial clients.
And what is your job title there?
I lead the energy services business.
Approximately how many employees are in your division?
We make up about a quarter of the company, so it's about 85, and that's focused on the engineering side of the business, as well as vertical market specialists, project management, and technicians.
The term ESCO, ESCO, is that fit a description for what you and your division do?
Yeah. The piece of business that I lead specifically really can identify best as an ESCO, which is an energy services company. To that effect, I'm actually on the board for the National Association of Energy Services Companies as well.
And tell the commission about your educational background.
I have a Bachelor of Science in Mechanical Engineering from Rose-Hulman Institute of Technology in Terre Haute, Indiana, and then I have a Master's in Business from Indiana University.
How long have you been at Harshaw Train?
Approximately 19 years.
Tell the commission what your duties are at Harshaw Train.
Well, I lead the energy services business, which is commonly known as an ESCO-type business. And specifically, I work with clients that are in the commercial and industrial space, healthcare clients, schools, industrials. And the part of the business I lead works with them to help them recapitalize their facilities.
after facilities have been used for a certain amount of time, they tend to wear out from an infrastructure standpoint. And my team helps these clients go in and address those issues in their facilities. And we take a unique approach where we usually fund those upgrades and those renovations to those facilities through existing operating cost. So we may go in and find energy efficiency opportunities that reduce the cost to the client and help them service the debt that they would take on by renovating the facility.
Do you work with Tom Obley?
I do.
And who is he?
Tom is Vice President of Harshaw Train, and he's my direct boss.
And do you work with him regularly?
I do, and I have for my entire career at Harshaw Train.
Are you aware that Tom is one of 3 directors of Kentucky Commercial Utility Companies, Inc.?
I am.
Was he able to be here today?
No, he had a prior commitment.
Are you aware that Tom attended a meeting a couple weeks ago, actually right over here at the 300 building with some clients of yours?
Yes.
And what, in general, what was that about?
Well, Tom's been involved with a lot of conversation around the utility industry and working with our clients to help their voices be heard in the utility proceedings that are going on in the state. And so that particular meeting was a National Governors Association grant meeting where Kentucky is one of a few select states that have received a grant to focus on some of the utility structure that's changing and evolving today.
And that meeting was just for commercial customers?
That's correct.
You're here as a witness on behalf of Kentucky Commercial Utilities customers. Can you describe what that corporation is and hopes to do?
Yeah, what our intent is to represent Kentucky commercial utility customers in these proceedings. We feel that that's a voice that hasn't necessarily been represented well and broadly in these proceedings before. A lot of our clients are commercial clients, and they've expressed a fairly healthy frustration with what's going on with utility rates and don't necessarily feel like their voices have been heard in these proceedings.
And they hope that KCUC will fill that void.
That's right.
How long have these discussions in general regarding the formation of this organization, how long have they gone on?
Certainly longer than a year from a conceptual standpoint. We've had conversations with many healthcare clients across the state around trying to get a quorum together and have a representation similar to this.
And in fact, were you and I in on a meeting about a year ago discussing the possible creation of one of these?
Yes, that's correct.
Okay. Is there a model that KCUC used as it was formed, as we formed it?
Yeah, the vision for KCUC is to really look something similar like a representative body like KIUC. They've done an admirable job representing the Kentucky industrial utility interest in these cases, and KCUC looks to mirror that to the extent they can for the commercial interest.
With respect to the particular stakeholders that assisted in the actual formation of this corporation, can you identify the 2 commercial customers of Kentucky Power that are supporting KCUC in this case?
Yeah, Appalachian Regional Health and BPM Lumber.
And what do you know about Appalachian Regional Health? Size or that sort of thing?
Well, they're a large healthcare provider in eastern Kentucky, and specifically they have 6 hospitals that are in Kentucky Power's service area. And they also happen to be the largest employer in southeastern Kentucky.
Okay. And the other customer of Kentucky Power that is joining in on this proceeding?
Yeah, BPM Lumber is a lumber operation also in eastern Kentucky, and they have 2 mills specifically that are taking power from Kentucky Power in their service territory.
Do you remember about how many employees they have?
Yeah, they're about 280 employees.
So just to be clear, both of these entities that you mentioned are commercial customers of Kentucky Power?
Yes.
And KCUC would represent their interests in this rate proceeding.
That's correct.
The Attorney General and KIUC have been granted intervention in this case. Do you believe that either could adequately represent the commercial customers in this particular case?
No, we really don't. The Attorney General's office has generally focused on the residential side of rate cases. KIUC has generally focused on the industrial, the IGS rate in this case for their members. And really what we're representing is most of what's in between those two from a rate and tariff standpoint.
Specifically, to your knowledge, has the Attorney General ever represented the interests of commercial customers in a rate case?
Not from a specific standpoint.
Okay. And have they, in this case, was there any contact from the Attorney General to you, Harshaw Train, about, helping to represent you in this case and your clients?
No.
Okay. If the commission grants intervention to another commercial customer, such as Walmart, do you believe that KCUC's interests could be adequately represented by Walmart?
No, I don't think so. Previous testimony stated as such as well, but Walmart has a very specific interest with a very specific profile and set of needs and concerns with regard to what their intervention is about. Our interest and our representation is more general. It's going to be broader. It's going to represent a broader basis of intervention.
So it could include smaller commercial customers?
Yes, it would.
What pressing issues are facing commercial customers in Kentucky that KIUC has been formed to address?
Well, just the two parties that we represent, ARH and BPM, based on calculations that we've done, they bear the brunt of approximately 1% of the overall rate increase, which is pretty substantial given it's two parties. In ARH's case in particular, that's an incredibly difficult financial burden. As I think many of you know, healthcare is primarily on fixed reimbursement, and so they don't have the opportunity to go out and raise prices or simply adjust their revenue model to account for that. And so it's incredibly burdensome for them in particular. More generally, there's a fairly large disparity in Kentucky's rate classes with regard to their competitiveness. And if you take a look at the EIA, the Energy Information Agency data, they will show that Kentucky currently has the 9th or 10th lowest industrial rate, and this is Kentucky in general. In the country. And they will show that they also have about the 10th lowest residential rate. Meanwhile, the commercial rates are about the 21st lowest. And so there's a fairly substantial disparity between the residential and industrial classes of customers and the commercial classes of customers.
And do you believe that this void from the absence of an organized entity representing commercial interests is what has led to that?
I believe that's some of it.
And what kinds of issues are in rate cases are commercial customers in general interested in?
Certainly cost of service is a big one, but once you get beyond establishing cost of service, rate allocation and potentially addressing that disparity between those different classes of rates. The elimination or aggregation of certain tariffs, like has been proposed in this case, sometimes that poses issues with regard to subsidization, and continued reliance on demand and associated penalties and things of that nature.
And do you believe that KCUC will be able to assist the Commission in dealing with those kind of issues, for example, the demand in this case?
I do.
And will that assistance take place in the form of submitting data requests to the utility?
Yeah, I think what we'd like to aid in is conducting appropriate discovery, and then also providing expert testimony.
And that expert testimony could be, for example, you or Tom. It could be outside, somebody outside as well. Is that correct?
That's correct.
That's all the questions I have.
At this time, Commissioner Cicero will have to leave, so we'll wait a second until he goes, and then we'll turn it over to counsel for Kentucky Power for any
I do
cross-examination.
have the ability to watch it on video, so.
You do.
I'm sure you will. Thank you.
He can't wait to get back and turn it on and see. Okay, is there a cross-examination for
Just a
Kentucky
couple,
Power?
Your Honor. Mr. Veerling, is that correct?
That's correct.
Well, first of all, congratulations on your alma mater. My son's in it.
Oh,
Also.
good.
You don't hear many people.
No, somebody that knows where it is.
Yeah, right. But I think you first indicated that one area of perhaps discovery and testimony would be in cost of service. Is that correct?
That's correct.
And that would be the company's overall cost of service. Would that be correct?
That's correct.
So that issue would be of interest to, and likely subject to discovery and expert testimony from the Attorney General and KIUC. Is that correct?
Likely, yes.
Okay. So really what your second issue, I guess, is that the way that cost of service is allocated among the classes.
Correct.
By my count, and there's that lawyer math again, there are 5 non-industrial and non-residential applicants. That would be you all, the League of Cities, the cable folks, Walmart, and the School Board Association. So that's 5 people issuing discovery requests to Kentucky Power representing the same group of customers, essential group of customers. Is that accurate?
Well, I think there's some special interest in there. For example, KLC and the street lighting. That's not going to be, municipal street lighting is not necessarily going to be a target area if KLC is omitted.
But when it comes down to allocated cost, it's a zero-sum game, right?
Yes, once costs are established, yes.
Okay. And so when costs are moved from the industrial class to the commercial class or vice versa, it typically affects everybody within those classes. Isn't it correct?
Yes.
And then I think you said that, I don't know if it was your firm or the Kentucky Commercial Utility Customers Organization has school clients?
No, my firm,
Your firm.
I have experience in, and my firm has school clients.
Okay.
So we're not representing them here.
You're not representing them here. And then, when was the case, is KCUC a corporation?
It is.
And when was it organized?
Just this month, recently.
Okay, and so from that, I would assume that if granted intervention, this would be the first time KCUC appeared before the commission.
That's correct.
Have you ever appeared before the commission?
No, I have not.
And then your associate, I'm sorry, all I know is Tom.
Yeah, Tom Obley.
Has he ever appeared in front of you?
Not that I'm aware of.
Okay, great.
Not in a formal hearing capacity.
Mr. Chandler?
Yes, sir. Just to go back for a second, Tom, what was Tom's last name that you referred to?
Obley, A-B-E-L-E.
And you mentioned that he was a director of KCUC.
He is.
And do you know if there are other directors of KCUC?
There are.
Do you know their names or how many there are? Or?
Yeah, there are 3 in total.
Okay.
Joe Grossman, who's the CEO of ARH, and the current the president of BPM as well. His name escapes me off the top of my
The president of BPM.
Correct.
Your Honor, do you want me to tell him who that person is?
Yes, please.
Richard Sturgill is the other director, current director.
That's the president of, you said that was the president of BPM
I think
Lumber,
he's actually
the
chairman of the board.
chairman. You mentioned you've kind of gone back and forth between all commercial customers and KCUC's members. Just to be clear, which group will KCUC be advocating if permitted intervention? Just their 2 members that operate in the Kentucky Power footprint, or will they be representing all commercial customers?
We will represent all commercial customers.
All commercial customers. Okay. And you were referencing the EIA data. Would you say that's the readily acceptable data on the EIA website referring to the cents per kilowatt or dollars per kilowatt per state per class?
Yeah, I would say that's one of a couple sources. It's pretty heavily cited, and it's government based, so it tends to be fairly reliable.
Is that the data you were referring
Yes,
to?
that's correct.
And do those aggregate between certain classes? Does that note what tariffs they take under, and what demand factors would apply? How are commercial, industrial, and residential defined on that EIA website? Are you aware?
I'm not aware.
Okay. You mentioned the question was asked that the answer alluded to that one of the reasons that you all felt, KCUC felt it needed to be represented, that the commercial interest needed to be represented, is because the Attorney General hadn't previously reached out to them. Is that a fair characterization of your answer?
Yes.
Did the Attorney General Are you a resident of Kentucky?
No, I'm not.
You're not. Okay. Are you aware of whether or not the Attorney General reached out to individual residential customers?
I'm not aware.
How about industrial customers?
I'm not aware.
So I just want to understand your answer. What is it? Is it your understanding that the Attorney General should reach out to organizations to ensure that they're adequately represented in these rate cases?
Not necessarily. To me, my position is the individuals ought to take on their own cause, and if the Attorney General chooses to take that up as well, then so be it.
Okay. And you noted, you answered that you understood that the Attorney General is generally focused on residential customers. Is that correct?
The outcomes the outcomes of rate cases in the past have seemed to lean more towards negotiations and settlements with regard to reduction in residential customers' tariffs and rates than they have commercial customer tariffs and rates.
And how is that related to the Attorney General's representation?
Because Kentucky commercial clients have not been represented specifically in cases before, maybe generally by the Attorney General. If the Attorney General has not accomplished a reduction satisfactory to the commercial clients, then the Attorney General hasn't necessarily represented them to their satisfaction.
And that's shown in the outcomes? Is that your opinion, that in settlements that's shown in the outcomes?
That's my opinion. It's also the opinion of the KCUC members, as well as other commercial entities that we have contact with.
One second, Chairman. That's all the questions we have for now.
Sarah?
Yes, good afternoon.
Hello.
I think we're both ready now. Mr. Verling, are you familiar with the tariffs that KCUC customers take service under?
Generally speaking, yes. Intimately, no.
In the motion to intervene, two of the tariffs were referenced specifically. The small general service tariff SGS and medium general service. And in the application, Kentucky Power proposes to combine the two into one. And is that one of the issues that KCUC will provide testimony or speak to?
It is.
Are there any other tariffs in particular?
There are numerous tariffs in there associated with, type of service inside of those tariffs as well, and so we intend to do some discovery on that and provide some testimony inside of those tariffs with regard to primary service, secondary service, those types of things as well.
And it sounds like that you or some of your affiliated members, fellow members, have done some work looking at past rate cases involving this commission. Can you speak to any other commercial entities that were permitted to intervene? We know that Walmart has been permitted to intervene in the past. Have there been other entities like that, to the best of your knowledge?
I'm not familiar enough to know. So
Okay.
to the best of my knowledge, I would say no, outside of Walmart.
And Walmart provided testimony earlier about their unique load characteristics. If you were permitted to intervene in this matter, when you speak about a broad representation, could you talk about that a little more, thinking about what Walmart is saying about their unique load characteristics? Are there other unique load characteristics?
Yeah, load characteristics can be very unique, but I think our position from an intervening standpoint is going to be a little bit less about what we would call the demand side, which is how the client uses the power, and a lot more about the supply side. What is the cost of power? How is the power structured? One of the things my firm does is we work with clients to optimize how they take the power once it's determined what the power structure, pricing structure is. And so I think generally speaking, we're going to be a little less sensitive to the load characteristics of those that we're intervening on behalf of.
We have nothing further at this time.
Commissioner Matthews, questions? I have a few. Can you identify by name or a town the hospitals operated by Appalachian Regional Healthcare that are within Kentucky Power service area?
Not all of them, but certainly Tug Valley is. I'm very familiar with that facility. I've done site surveys and worked directly with Tug Valley. ARH in total has, I think, 13 critical care facilities. They're spread out all over eastern Kentucky, and then there's even a couple over in West Virginia as well, in Beckley and other places. Hazard, and I am not sure which other ones specifically. I don't have my notes with me to have that detail on it, but we've done a specific rate analysis on the ones that are in their territory, and ARH is, if they do nothing and just simply transfer rates over, they're in line for about $415,000 rate increase across those 6 facilities.
Well, I wondered because I think there are 7 ARH hospitals in Kentucky, and there were 5 that I think are in Kentucky Power's service area, and one would be Tug Valley, Whitesburg, Hazard, McDowell, and probably West Liberty, but I'm not sure. Then there are hospitals in Harlan and Middlesboro,
right,
which would be, I think, in Kentucky Utilities territory, probably. At this time, can you tell us whether or not any officer or director of Kentucky Power Company is on the ARH Board of Directors or trustees?
I think a former Kentucky Power associate is on the board.
Is that Mr. Pauley?
I believe so.
And he's immediate past president of Kentucky Power?
I believe that's correct.
Are you familiar with how ARH is primarily funded? Do you think they get most of their money from the patients who visit their facilities in the area they serve?
No, they're primarily Medicaid reimbursed.
Do you know if they also receive grants from the Commonwealth of Kentucky and from the University of Kentucky?
I know they have a partnership with University of Kentucky for certain facets of their services. I don't know what it all entails or what type of remuneration is provided.
Other than the lumber company and Appalachian Regional Healthcare, Inc., statewide, are there any other members of KCUC at this time?
Currently, no.
So those are the only two members of KCUC
Correct.
at this time?
That's correct.
And to be a member of KCUC, does a member have to pay dues? Do you
We're
pay
still-
something? How does that work?
We are still working through all of those details. We've just recently formed, and we'll be working through all of those details here in the next couple of months.
I have no further questions. Mr. Gardner, anything further?
No further questions, Your Honor.
Anything?
You asked my only question.
Mr. Chandler?
Just a couple. Thank you. You mentioned earlier that one of the reasons the KCUC was incorporated and decided to get involved in rate cases was and correct me if I mischaracterized that. You saw a disparity between the outcomes in rate cases before the Service Commission and a disparity towards the commercial class. Is that correct?
That's correct.
And in response to Commission staff's question, I believe counsel for Commission staff asked if you were aware of other commercial customers that were permitted to intervene. I believe you stated that you were not familiar enough to answer, and to the best of your knowledge, no. Is that correct?
On others that have intervened specifically, that's correct.
Other customers that take under commercial classes? So, how is it that you're unaware of the involvement of commercial customers in cases, but yet you can make the characterization that due to not having commercial customers involved or commercial organizations involved, they were treated unfairly or had inadequate representation in an outcome?
Because I study rates fairly thoroughly. I have a team of engineers that work with me that do a significant amount of rate analysis and rate history. And we watch specific classes of rates and the adjustments made to rates that come out of these cases. And when we see that, we can see a fairly clear general difference between the rate of increase and the rate of allocation associated with commercial and the other classes of tariffs.
But to follow up, in that study, do you look at whether or not commercial customers were represented in that case specifically, beyond the Attorney General's representation?
No, we don't cross-reference that.
So what you're saying is, your opinion is that the outcome is disparate for commercial customers, yet you're not aware of whether or not commercial classes were actually represented in those cases?
I'm not specifically aware of if they were represented, yes.
Are you aware of the most recent Kentucky Utilities and Louisville Gas and Electric rate cases?
Generally.
Generally? And are you aware of the outcomes in those cases?
They're just now being finalized, so I have some knowledge, but not thorough.
And would you be surprised to find out that there were Kentucky's two largest cities who take under multiple commercial tariffs, Kroger, the Kentucky School Board Association, and Walmart were parties to either or both of those cases?
I'm familiar with that.
So the questions asked.
Pat, any questions?
We have no further questions.
Commissioner Matthews? Is what you're saying, Mr. Verling, that irrespective of who had intervened in other cases to represent commercial customers, that in your opinion they weren't represented very well?
I think my opinion is they were represented very specifically to their interest and not necessarily to general interest, specific to the rate case. And I think we heard that earlier in the testimony of Walmart today. They are here to represent a very specific interest that happens to be specific to their needs and their loads. And our interests are going to be to represent a broader set of interests and more general positions than specifics like that.
And specifically those two clients, because those are the only two clients that you have at this point.
Correct. Correct, but those two clients take power across numerous tariffs. They're not just sitting inside of one or two tariffs, inside of Kentucky Power's rate tariff schedule. They take power on approximately 10 different tariffs. So there is no way to specifically just represent one piece and not the whole.
I have nothing further, Mr. Gardner.
No other questions, Your Honor.
Anyone else? Okay, so you may be excused. Thank you. Mr. Gardner, if you'd care to summarize your client's position, we'd love to hear it.
Thank you, Your Honor. It's no surprise that KCUC was modeled literally after KIUC. There's no doubt that commissions, the Commonwealth believes that KIUC has been excellent in its representation of the industrial interests in Kentucky, that they've done a great job. They haven't hindered the rate cases. They've zealously and adequately represented that industrial interest, that industrial customer, which, like the commercial customers, they're large and small. And but the commission requires that they name at least one member of KIUC who is an actual customer. So KIUC likewise may be representing all industrial interests, even though 1, 2, or maybe 3 are actually named as the member that actually takes power, which the commission is required to pass. And that's the model that we've adopted here. We're new, acknowledged, but this is an interest this is a need that has been expressed for a long time and have been working on it to try to be involved in this need so that the commercial customers who take under different tariffs, as Mr. Vierling says, a broad interest of tariffs will represent the commercial interests generally. Modeling again after KIUC in the pleading, we named two members who take electricity, two pretty large customers who take electricity. So we meet one of the standards, which is that they have a special interest that's not adequately represented. I don't think there's, in spite of Mr. Chandler's questions, I don't think there's any realistic notion that the Attorney General is out there representing commercial customers as well. Again, as the prior witness indicated, interests may be aligned in trying to reduce the overall rate increase, but once one gets into rate design and rate allocation between classes, the Attorney General's office does not represent the commercial customers because of the potential conflict with residential customers on rate design. Again, we have a special interest, and as Mr. Vierling said, we represent a broader interest than Walmart, which is one customer. And specifically, there's testimony that the areas that we will assist the commission in are cost of service, allocation between classes. That will be one of the major points of testimony, is trying to look at cost of service studies so that we can see how much should be allocated to each of the classes. Potential elimination of certain tariffs, the demand charge, which is not unique to commercial customers because industrial customers also have demand charges, but that's an important one because there's a feeling in commercial customers that those demand charges continue to escalate way high. And then the combination of the two rate designs. So we feel that we've met the standards established by the Commission and its order of about 2 weeks ago on what is necessary in order to have intervention. So thank you.
All right. As with every other movement in the case, Mr. Gardner, you and your client may be excused, or you may stay for the one last hearing and then get the final statement from counsel for Kentucky Power, perhaps the Attorney General as well. Although I will say this, and I know when the witness testified, there was no, he didn't intend to particularly, I don't know, demean or diminish the quality of representation of the Attorney General's office, because from the time I've been here, Mr. Chandler and others, Mr. Cook and others of their staff have done, in my opinion, a yeoman's job on behalf of the people they represented. So,
I can say that the Attorney General takes no offense.
And there was no offense on my part.
well, that's what I want to point. I didn't think there was. I'm sure there wasn't.
They do an excellent job. In the last case, they had 5 expert witnesses, and they led the negotiations that resulted in the
But if I'm not a party to a case, or I'm an attorney and I represent a client, and I see a result, I might not be very well satisfied with it either if I wasn't a party. I understand the situation. Okay, thank you. Would Progress Metal Reclamation Company, D/B/A, Man's Get Back Metal Company, please come forward. I'm sorry you had to wait till the end of all this, and but that's just how it had to be, I guess.
I guess it was the hour. I wish the motion to intervene was filed, but that was unavoidable.
Okay. Would you please identify yourselves as counsel and your witness?
My name is Dennis Howard II. I'm with Howard Law. I'll be representing the company today. I have Matthew Hart with me to my right, and John Wolfram to my left, who is with the Catalyst Consulting Group.
Thank you. Right. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Now you may be seated, and Mr. Dennis, you may ask.
Thank you, sir. Would you please state your name and business for the record, please?
My name is Matthew Hart. I'm employed by Progress Metal Reclamation Company, DBA Man's Back Metal Company. They're located at 1900 Front Street in Ashland, Kentucky.
And how long have you worked for the company?
It'll be 21 years this September in various capacities.
Your current capacity, what would that be?
I'm the facility manager.
Okay, and your current title?
I'm also a vice president.
Can you give me an overview of your current responsibilities?
Sure. Basically responsible for the operation of the facility. That's from overseeing the scrap procurement volumes to production volumes, and then filling customer orders, and ultimately the financial results of that entity.
In your company history, and I don't want a treatise on it, but if you'd be kind enough to kind of give the commissioners a little information, if you would. We indicated in the motion to intervene that you are basically a heritage in Ashland. Can you explain that for us?
Yes, be happy to. We have an extensive heritage in Ashland. Hopefully, next year we'll be celebrating 100 years of continuous business and employment in the Commonwealth. In 2018, we'll meet that century mark. We are a metal recycling facility, and basically we have a shredder that incorporates a 6,000 horsepower motor to generate the power to shred the material that we process there. We think it's the only operation of its kind in Kentucky Power's service area, being that type of a shredder, And the nature of the equipment is to use a very high volume of electricity, 5,000 plus kW, during brief periods when we actively shred the raw material.
Can you describe the company's operations from, let's say, 2010 to the current date?
The shredding operation has been reduced from 2 shifts in 2010, 2011 to a single shift in the 12 through 14, 2012 through 2014 period. And now we're just operating on a few days on a single shift from 2014 to the current period. Also during that time, we ran the shredder during off-peak hours for approximately 12 months, beginning in September of 15, until that proved to be just marginal savings as, management decided that, we were losing operational efficiencies by running 2 separate shifts.
Yeah, and your production since 2010, how is that, can you give me some background on that?
We've experienced a cumulative loss of roughly 68% of our gross tons of shredded metal that we produced. That's from 2010 through 2016. The reduction in these tons of shredded metal over these periods is basically because of a low market value for steel, which correlated into reduced market value of the scrap metal, and then a gradual and then more sudden loss of sales to our primary steel customer. Combine that with an operation that is highly equipment and capital intensive, has just resulted in extreme financial pressures and severely restricted our operations. Recently, we have been able to be a little more successful in expanding our sales away from our primary steel customer, but that involves additional transportation costs. We are located on the river. We're able to go to the river, via barge, but still we did have additional transportation costs that we prior weren't incurring because the steel mill was located basically adjacent to our property there in Ashland.
And if I can sum that up, so you had a pretty rough spot for a period of years. You managed to punch through that, and now can we characterize it as recovering?
Yeah, a couple years ago, I don't think there was any light at the end of the tunnel, and now it's maybe a dim light there. I think with the current administration and at the state level and at the federal level, I think we're going to hopefully seems to be a little life, on the industrial side coming back around. Basically our problems are that, we go the way the steel industry goes. Okay, so when they catch a cold, we catch the flu. Is basically how I've summed that up.
So you bounce back, and then by the time you get your sea legs back, and then the company comes in, the company being Kentucky Power, they request an increase in electric rates.
Right.
But let me ask you a question. How long have you been looking at your electric rates as it relates to your business?
Look at them every month. Is that what you're?
Well, and then also the rate, the impact of the electric bills on the just general operations. Have you been looking for a while to find out if there's a way to see if there's something that you could do to reduce your electric rates?
We have, in fact, that's why we went to the off-peak, trying to save that for that 12-plus month period. And then because of extended layoffs, we ended up operating 2 shifts with minimal people, and that became very inefficient.
Can you explain why you're here to testify today?
I'm here to testify on our motion to intervene.
And have you ever testified before the Public Service Commission before?
No, sir.
Do you know what a motion to intervene means?
it's our company's attempt to request and be granted the opportunity to participate in the Kentucky Power Company's request for a rate increase.
And as the chairman pointed out, that we kind of drew the short straw that we were last to go today. So we've had the benefit, though, of listening to a lot of the other testimonies that have taken place. And we've heard the question over and over. So I'll ask you, just flat out, why should Progress be granted full intervention in this case?
Okay. We feel like that we have a special interest in this proceeding that is not otherwise adequately represented, at least to the best of my knowledge. Specifically, our operations create a very unique load profile with a low load factor. Even when the shredder operated, normally at 2 shifts, it was even a low load factor, but at that time we had volume. We had volume to mitigate that cost. However, the deterioration in our load profile serves to, create this special interest that's not represented by anybody else in the proceedings, I guess. Our special interest is also amplified by the extremely high rates that we are currently paying due to the demand charges and the severe financial impact of the proposed rate increase, which is heavily weighted towards that demand charge. Our facility has been paying anywhere between 21 and 47 cents per kilowatt hour, and that's including taxes since January 16, January 16. This high cost of kilowatt hour is basically because we're running the shredder fewer hours and with the same level of peak demand, that just translates into a low load factor of somewhere between 5 and 10%. As I said earlier, we've, for an extended period of time, we tried to operate, the shredder, on the, to exclude it from the on-peak demand, when we period, but we still experienced a very high cost of kilowatt per hour due to the minimum demand component, which bills us for 60% of the prior 11-month peak or the contract demand. We're obviously wanting to evaluate participation in the demand response program that's out there, although I don't think that will offset the current proposed rate increase, which we estimate conservatively to be approximately $359,000 per year, and that's based on 5,500 kW of demand and 325,000 hours of kW each month. The rate increase will add an additional 10 cents per kilowatt hour on our average, which will bring the average bill to approximately 45 cents per hour of kW. And those estimates were based on the inclusion of taxes, just the whole. So obviously the proposed increase creates a significant cost for us on a perpetual basis, especially in light of the financial hardships we've already shouldered, over the past few years. We think we can present the issues and develop the facts that will assist the Commission in fully considering the matter without unduly complicating or disrupting the proceeding. In particular, we'll explore the potential modification of Kentucky Power's approved economic development rider or development of a new load retention rider to alleviate the severe impacts of the proposed rates on our operations.
And some of the numbers that you just provided in this last answer, are you familiar with those? And did you prepare those, or were those prepared for you?
Those numbers, I'm familiar with them, but those numbers were provided by our company's energy consultant.
Are you familiar with an economic development rider?
Not specifically, but it's been explained to me by our company's energy consultant as well as our company's rate expert. Mr. Wolfram, who is here in attendance, is our company's rate expert, and he'll be here to testify as well on that issue.
And then I'll ask you the same with regard to the low retention rider. Are you familiar with that?
Same answer as previously. You know, it's been explained to me in the general terms, and you know, our experts can testify to the specifics.
Similar to the question that's been asked of other parties today by staff in particular, I'll ask this of you as well. First of all, you're aware that the Attorney General's office and the KUC have been granted intervention in this case, correct?
Yes, sir.
And do you believe, based on your understanding of what you've heard today, that either of them can adequately represent Progress's interests in this case?
From what I understand, you know, I think the Attorney General represents all taxpayers in a rate case, and you know, however, you know, frequently other parties are granted intervention. For example, in the case at hand, KIUC has been granted intervention because KIUC focuses on industrial customers. You know, I understand from you that KIUC represents Air Products and Chemicals, Inc., Airgas, AK Steel Corporation, Catlettsburg Refining, you know, in this case at hand. You know, Progress is an industrial customer, and I have no doubt that our energy consumption is completely different than that of the KIUC customers in this case. In fact, based upon my understanding of Kentucky Power's ratepayers, I'm confident or feel like there's very few other customers in their service area that is like us, you know, with the shredder operation there. I guess maybe stated another way, out of approximately 168,000 customers that Kentucky Power, I think, you know, we're probably very unique in our electricity consumption. I do want to emphasize that I've been told, you know, that the Attorney General's office and KIUC do an excellent job in the representation of those ratepayers. However, KIUC will focus on its customers, and the Attorney General is not likely to be as concerned about, you know, one outlying customer, you know, when it's dealing with the 168,000 customers issues, you know, with which it needs to deal with.
And that one outlying customer would be you, correct?
Yes.
Given your
That's
low
what
profile.
I understand.
Given your low profile.
Yes, because of the load profile, low load profile.
Mr. Chairman, I think that's all the director I have at the moment.
Thank you, Mr. Howard. Mr. Overstreet?
Thank you, Mr. Chairman. Mr. Hart, is it?
Yes, sir.
Okay, thank you. What tariff does Progress?
It's the IGS sub-transmission.
IGS sub-transmission?
Yes, sir.
Okay. And if I understood your motion and then your testimony here this afternoon, and please understand me, I'm not trying to trivialize the economic realities facing your company, but that the two drivers that you're facing is what your motion describes as an extremely low load factor. Is that one of them?
Correct.
And that in turn is driven by the current low price of steel.
Well, the low load factor has to do with, from what I understand, because the shredder has a 6,000 horsepower motor. When it fires up, it uses it intermittently.
Right. But
Okay.
if steel were worth more, you could run your shredder for longer periods, and then your load factor would be higher. Is that correct?
I guess because of the plight of the steel industries in our country, where they've been operating at, quite a few of them have been mothballed. As an example of AK Steel there in Ashland, idled their facility in December of 15. So that's the culprit as far as we're concerned in That's why our utilization has decreased.
And I think you indicated that you had a steel, you were located near a steel mill. Was that AK Steel?
Yes, sir.
Okay. Are you aware that Kentucky Power has filed with the Commission a CSIRP tariff?
I'm not familiar with that.
And that tariff actually allows customers who are able to interrupt their operations a monthly KW credit of $3.68.
That's the demand reduction rider you're talking about?
Well, it's CSIRP.
I didn't know the acronym, I'm sorry, not versed in the
Sure,
language,
but
okay?
I just want to make sure you and I are talking about the same thing.
Yes, and I think I did reference that in some previous testimony here that we do want to participate in that.
But you're not participating in it now?
No, sir. Okay.
And I think you indicated that one of the concerns that Progress has is the demand charge. Is that correct?
Yes, sir.
Now, a demand charge, you would agree, is intended to allow a utility to recover its fixed costs.
I'm going to defer that question to our consultant because I'm learning the vernacular of the language, okay? So I don't want to, I don't want to jump in and say I agree when I may not have the understanding of that correctly.
And is the consultant going to testify today?
Yes, sir.
Okay. All right, fair enough. And finally, I think both you and Mr. Howard refer to Progress as an outlying customer among Kentucky Power's approximately 168,000 customers.
That's what I understand, yes, sir.
Okay, great. Thank you. That's all I have.
Mr. Chandler?
Yeah, I'm sorry, I didn't catch your last name when you spoke earlier.
Hart, H-A-R-T.
Mr. Hart, thank you.
Yes, sir.
Mr. Hart, I asked you the question I had asked the earlier parties. If granted intervention, and can I refer to the entity as Progress, is that understood? Does Progress intend on conducting discovery and filing testimony on the issues that you've discussed today?
Yes, sir.
That's all the questions I have, Chairman.
Ms. Vincel?
Yes, I have a few questions. Good afternoon, Mr. Hart.
Good afternoon.
And if I ask you anything that you wish to defer to Mr. Wolfram, please let me know.
Thank you.
Now, make sure that I understand that at one point in time in the fairly recent past, Progress was able to run 2 shifts and then move to 1 shift. And was that shift operating on a daily basis or 5 days a week?
Yes, ma'am. It went from, the first 2 years we were on, basically 2010 through 11, we were basically 2 shifts. And then we went to 1 shift on 12 through 14. And that 1 shift could have been, that was during the day. Mm-hmm. And then subsequent to that, we took that 1 shift that we still had on the shredder to a night turn to try to go off peak to try to save some, have some savings there. And now we're just operating really on intermittently, maybe 3 days a week.
Thank you. That was where I was going to want to make sure that I have followed the trail of that.
Unfortunately, you're following the trail.
When you spoke about the load factor right now, the unique profile, when Progress was operating 2 shifts, what was the difference in the load profile at that time versus what it is now?
I would have to defer that question to, the experts.
Mr. Wolfram? Okay. And you've testified that Progress is interested in, and what Mr. Overstreet identified as tariff CISRP, the interruptible, and you were interested in it. Has Progress done any study or analysis?
We have recently, yes, ma'am.
And how recently?
Just in the last few months. I just I assumed the responsibilities of the facility manager a couple years ago, and that's when you sort of get into the intricacies of expenses and so forth, and I wish I knew about it in 14.
That's an understandable statement. You've touched upon KIUC and the fact that they represent industrial customers. Is it a fair characterization of your testimony to say that KIUC cannot adequately represent Progress's interest due to the low load factor?
Yes.
And that's the primary distinction right now.
Yes, ma'am.
We have no further questions at this time.
Mr. Matthews, questions?
I have none.
Mr. Hart, where is your facility located, in Boyd or Greenup County?
Boyd.
And AK Steel's in Russell, which is in
It's in
Greenup County, right?
No, it's in Boyd County. It's
It
on
is
the
in
line.
Boyd County.
Yes, sir.
So is it operating at all now?
I think they're running their casting line, which is just like a finishing product that they moved down from the Middletown facility. But no, they are not melting any scrap. The blast furnace is idled.
So when you sell your product, where do you sell it? You load it on trains or something?
We'll do it by train, truck, or barge. We are on the river. We're in between rail and the river, our location, so we do have dock availability to load our material out via barge.
No further questions. Anything further, Mr. Howard, at this point?
Mr. Chairman, I don't have any redirect for this.
Okay, nothing else? Okay, you may be excused and call your next witness.
Mr. John Wolfram, Mr. Chairman, please.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do, sir. Okay. Please be seated, and Mr. Howard, you may ask.
Please state your name, business address, and position for the record.
My name is John Wolfram. I am the principal and founder of Catalyst Consulting, LLC, a rate and regulatory consulting firm located at 3308 Haddon Road, Louisville, Kentucky, 40241.
And on whose behalf are you testifying today?
I am testifying today on behalf of Progress Metals Reclamation Company, doing business as Mansback Metal Company, which I'll refer to as Progress.
It'll be a lot easier for everyone if we just keep it Progress. Can you describe your education and work experience briefly?
Sure. So I received a bachelor's degree of electrical engineering from the University of Notre Dame, a master's degree in electrical engineering from Drexel University in Philadelphia. I spent the first 6 years of my career at PJM, spent as an engineer, 1 year with Cincinnati Gas and Electric Company, 14 years in various roles at Kentucky Utilities Company and LG&E. Then I joined a rate and regulatory consulting firm called the Prime Group. I was there for 2 years before founding Catalyst Consulting in 2012. At Catalyst Consulting, I provide rate and regulatory services, cost studies, rate design for electric utilities, investor-owned utilities, municipal electric companies, and cooperatives.
In your experience, do you have particular rate-making knowledge and history with economic development rates?
I do. So when I was at LG&E, I managed the regulatory affairs department, and so I oversaw rate cases. I was also director of customer service and marketing, which included the economic development department. And so I have personal experience with that intersection of rate making and economic development. And as a consultant, I've assisted electric utilities with researching EDRs, economic development rates, with implementing EDRs, with special contract negotiations for EDR customers, and with educating utility stakeholder groups on economic development strategies. And I've also been invited to speak at several national conferences on economic development strategy for utilities and economic development rates.
And have you ever testified before this commission?
Yes, I've testified before the commission numerous times.
Can you give me an overview of the on the purpose for your testimony today?
Sure. So the purpose of my testimony is fourfold. First, I'll give a very brief description of EDRs and how they operate. Second, I'll give a brief description of load retention rates and how they operate ordinarily. Third, I will describe the circumstances under which the implementation of a load retention rate is appropriate and why this case presents those circumstances. And fourth, I'll explain why the concepts of a load retention rate that Progress proposes in this proceeding will assist the Commission in its considerations of this matter, as well as how it will address the special concerns of Progress in this case.
In terms that hopefully we can all understand, can you tell me what an EDR is?
Sure. So an EDR is an economic development rate. It is a an incentive rate offering that supports economic development. In this context, economic development is ordinarily thought of as having three components. The first is attraction, for attracting new customers. The second is expansion, for expanding the load of existing customers. And the third is retention, for keeping the customers that are already in a utility service territory. Those rates do that ordinarily by providing some kind of a credit against electric bills, which we could refer to as a discount. And the economic development rates ordinarily address those first two components of attraction and expansion.
And what is an LRR, load retention?
An LRR, a load retention rate, is another economic development offering, an incentive rate offering that supports economic development to address that third component, which is aimed at the retention of existing customers. And Kentucky Power has a tariff EDR approved right now, which addresses those first two components, the attraction and the expansion elements of economic development. But the tariff doesn't address the retention aspect, nor does Kentucky Power have a standalone load retention rate, either of which would address Progress's concerns that it's raised in its motion in this case.
And I think you touched on this, but how does an LRR ordinarily operate? I mean, can you go into just a little bit more detail on that?
Sure. So ordinarily, a load retention rate will provide a credit towards a commercial or industrial customer's base rate demand charges for a limited period of time. And that kind of a discount to the demand charge will ordinarily be phased out over a number of years, after which the customer would begin taking service under the standard rate offering applicable to it based on its qualifications.
So is LRR similar to the EDR?
Yes, the LRR is very similar to an EDR, similar to the EDR that the Commission has approved both for Kentucky Power and for almost all of the electric, a large number of the electric utilities under its jurisdiction. The difference really is that the LRR applies to existing customers who are absent some kind of discount on their existing rate, would be faced with potential closure or severe restriction of its operations. And so that's really the difference. It's basically just like an EDR, but for the fact that it's applicable to customers who are already here, but who are under financial duress.
And in those situations, the LRR provides temporary relief that helps avoid the adverse business outcomes, correct?
Yeah, that's right. It's basically an LRR would provide some temporary relief to customers who are under some financial duress, and since that relief is temporary and phased out over time, it allows the business, it supports economic development really by allowing the business to remain in business and to keep economic development within the Commonwealth, within the community at large.
And by keeping that business as healthy as possible, it helps all ratepayers out in the long run, does it not?
Yeah, the aim, if the rate is properly designed, it would be mutually beneficial both to the utility and to the individual customer without having adverse impacts on the remaining customers and customer classes of the utility.
In this proceeding, do you see those circumstances existing for Progress to be able to participate in the LRR?
I do. So in my view, in the testimony of Mr. Hart and the way he described the business situation that Progress finds itself in, Those conditions are very consistent with those in which a load retention rate is normally justified by other utilities.
Do you believe the concept of the LRR introduced here, do you think that addresses Progress's special interest in the proceeding?
I do. I think the conditions described by Mr. Hart set forth a special set of circumstances and for which a load retention rate is a very sound and reasonable way forward that could be mutually beneficial both to Progress and to Kentucky Power.
Is that special interest otherwise represented that you've heard of through the testimonies and seen in the motions to intervene?
Yeah, I don't think it is. In my view, it's unlikely, and that's primarily because Progress's load factor is low. Mr. Hart testified that that load factor is in the range of 5 to 10%, and in my review of Kentucky Power's data provided in response to a commission data request for supporting its filing, the average load factor for the IGS class at subtransmission is something in the range of 79 to 89%. And so I think in that respect, Progress is likely to be unique. And also, I think Progress, at least so far, appears to have a special interest that's unique because no other parties, certainly industrial parties, have proposed a solution like a load retention rate which would address those particular concerns raised by Progress.
If I heard or recall correctly a moment ago, Mr. Overstreet asked Mr. Hart the tariff under which Progress took their service, and the response was the IGS sub-transmission. Is that correct?
Yes, that's my understanding.
And in your review of the information in the application and the response to the PSC responses, do you know what the average Kentucky Power IGS load is for IGS subtransmission?
I do. So the load factor for that particular rate subclass is calculated in two ways, and the lower of those two numbers is 79%, and the higher of those two numbers is 89%.
And again, it's Progress's understanding of their load that they are in what range?
They are estimated to be in the range of 5 to 10% load factor.
The concept of the LRR we plan on introducing in this litigation, do you think that will assist the Commission in fully considering the matter at hand?
I do. I think the load retention rate could assist the Commission because it's a method, a rate-making option that is consistent with standard and generally accepted rate-making practices. It's consistent, in my view, as Progress would propose it in this case. It is consistent with the Commission's existing orders regarding economic development rates. And in that sense, I think it provides a path, really, for Progress and for Kentucky Power to collaborate on finding a solution to Progress's challenge in a mutually advantageous way.
Do you think advancing that concept will unduly complicate or disrupt this proceeding?
No, not at all. I think the proposal of this kind of a load retention rate or a modification to Kentucky Power's existing economic development rate, tariff EDR, to allow for a retention aspect would be, as I said, consistent with Commission practices and prior orders. And for that reason, it would not prove disruptive, but in fact would be constructive and, again, allow a collaborative path forward. And for the Commission, it would allow them to oversee that process in a way that is preserves or prevents, rather, any adverse consequences to the remainder of Kentucky Power's ratepayers.
Mr. Chairman, that's all the direct I have at the moment. Thank you.
Thank you, Mr. Overstreet. Carl?
Thank you, Mr. Chairman. Mr. Wolfram, I was asking Mr. Hart, and I think he deferred to you, the question of the purpose of a demand charge. Would you agree that demand charge is intended to recover a utility's fixed costs?
Yes, I would agree.
And so, and then I think you indicated that the load retention rate that you're proposing would take the form of some sort of credit or discount for, against that demand charge.
Yes, that's correct. So in the same way that Kentucky Power's existing EDR offers what I'll call a discount to the demand charges for customers of it for attraction and for expansion purposes, what we would propose to be to offer a similarly structured credit towards demand charges for the retention purposes. That's correct.
And so in connection, let's say it this way, with an EDR, that's not a load retention rider. There's new load coming on.
That's correct.
And with an LRR, the load is already there. Is that correct?
It is correct, yes.
Okay. So who pays for that discount or credit that under the LRR?
Right. So ordinarily, let's say the discounted revenues that the company would forego by offering this, those costs would ultimately be borne by shareholders in the same way they are under the tariff EDR today for the expansion and attraction customers. So the other ratepayers would be held harmless from that.
So it's your proposal that Kentucky Power shareholder, American Electric Power Company, Inc., cover the cost of this LRR?
Yes, that's correct. Consistent with the way the EDR would work today, and consistent with the idea that as long as the customer is continuing to not only to pay a cost that exceeds its marginal cost, in other words, it's paying all of its variable cost and making some contribution to fixed costs, then that is what ratemakers consider to be a reasonable structure for a load retention rate.
Isn't it true that the only reason that Kentucky Power is not recovering cost under the existing EDR is that was implemented in between rate cases?
I don't know. I do know that because I'm not familiar with under what circumstances Kentucky Power implemented the EDR to begin with, but I do know that certainly in other jurisdictions, and my understanding is in the Kentucky jurisdiction for the EDRs that the Commission has approved, and in the administrative case in which the Commission studied economic development rates, that the Commission set forth a requirement that the other ratepayers not be harmed by providing this sort of a break on demand charges by any EDR, whether it be for retention, attraction, or for expansion.
Is there any other utility in the Commonwealth that has an LRR?
The only other utility in the Commonwealth that has an LRR, so my understanding in reviewing the tariffs of the other utilities is that Duke Energy has an economic development tariff called a DIR tariff that there is a paragraph in that tariff that allows the tariff to be applied to an existing customer, so for retention purposes under a certain set of circumstances. And my understanding is that Duke Energy is the only one that has that kind of language in its approved tariffs today.
And when you were with LG&E and KU, did you propose a load retention rider?
Now, when I was with LG&E KU, we did not, and frankly, I don't think any utility is ordinarily, in the normal course of business, has the incentive to propose that kind of rate absent basically the direct request or appeal from a customer who is facing these kinds of circumstances and who needs that kind of temporary relief in order to avoid either a closure or a relocation or a severe restriction of its business operations.
And
if they did want to, the Commission has set forth specific requirements that must be met in order for the utility to do that in a way that allows the tariff to be approved.
But you've never, I'm sorry, I didn't mean to say you, but Progress did not participate, to your knowledge, in Kentucky Power's EDR case. Is that correct?
I'm not aware of which parties participated in that proceeding.
Are you aware of any other IGS customer, sub-transmission, or otherwise that has a load factor as low as Progress?
No, I'm not.
I think that's all I have, Your Honor.
Mr. Chandler?
No questions.
Mr. Benson?
Just, I think one question to follow up on what I asked Mr. Hart. When Progress was operating 2 shifts per day, would their load factor have been higher than it is currently with the 1 shift operating intermittently?
Yeah, I think it's reasonable to expect that the load factor would have been higher. I'm not able to say how much higher or to quantify the amount, but I do believe that it would have been higher because it would have contributed a greater amount of energy presumably without a change in the peak demand. And so, yes, it would have caused the load factor to increase, but I don't know by how much.
No further questions?
Commissioner Matthews?
I have nothing.
I have nothing. Mr. Howard, anything further?
Just one point of clarification. When you were going through the criteria for the implementation of the LRR, I think you said closure, relocation, or severely restricted or limited operations. And there, I think that's somewhat subjective, is it not? I mean, it depends on, it varies from one utility to the next, correct?
I think it varies from one customer to the next. So the requirement to state that the customer is going to have business operations severely restricted because of its electric bill and that financial duress that it's currently going through is really, that burden is on the customer and not the utility. So if the customer can point that out or assert that or demonstrate it, then I think and really that's why I'm here, because when Progress explained the circumstance, I said, well, that sounds like the kind of condition in which I've seen other utilities adopt a load retention rate. It seems like ripe conditions for that, and that's the focus. So I think in this case, it can certainly vary by utility, but more importantly, it can vary by the individual, industrial, the business or large commercial business, and the conditions under which it's currently operating. So as to whether or not it would require that kind of temporary rate relief for economic development purposes.
And just to follow up on that, your analysis of the load retention riders, here today as a consultant, or depending on your capacity as a consultant or as an expert, you review these cases from the side of the utility, haven't you?
Yes, historically I have I've only represented utilities for rate-making purposes in these proceedings. This will be the first time I've represented an entity that's not an electric utility. And the reason I'm doing that is because the customer put forth a scenario that said, look, this is our set of conditions right now. We are facing this challenge with our electric bills being high, and it's our understanding that maybe there's a solution to this. And I said, that's correct. My experience in this area shows that the load retention rate is a potential solution, and I would be willing to come here and describe those kinds of conditions and maybe put forth some proposed either revisions to the tariff EDR or some additional language for a load retention rate that would potentially be mutually advantageous in this situation.
Thank you, Mr. Chairman.
Mr. Overstreet, anything further?
No.
Mr. Chandler? Ms. Hansel?
No, Your Honor.
Commissioner Matthews, any
No.
questions? I have none. With that, you may be excused.
Thank you.
Mr. Howard, please feel free to summarize your client's case.
Thank you, Mr. Chairman, and given the hour of the day and it being rather late, I'll be as succinct as possible. Mr. Wolfram concluded by stating that this is his first time in testifying on behalf of a ratepayer when it comes to the load retention riders. Progress has made it clear that they've looked at EDRs. They have done what they can to alter their electricity consumption. They have a very unique load profile, one that they've tried to maximize insofar as being able to save on their electric bill. And they understand completely that all of East Kentucky's ratepayers are suffering a lot of hardship. They are a commercial or an industrial enterprise here. They have a very special interest. KIUC does have a seat at the table. They have a completely different load factor based on the 4 or 5 customers that they put forward. The AG has 168,000 other customers. Progress is an outlier. They are advancing at least two different concepts that we believe would assist the commission in rendering its decision. So they are special and they're not adequately represented. They have issues and facts that they can develop, and they will not complicate unnecessarily, or hopefully, I don't believe they'll complicate these proceedings whatsoever. They will bring issues and facts to the table. I think that they should be granted intervention. Thank you, Mr. Chairman.
All right, now we're at the close of the proceedings, and so, Mr. Overstreet, if you'd like 15, 20 minutes or whatever to summarize your client's position with respect to one or all of the proposed intervenors or anything else relevant to this proceeding, please do so.
Thank you, Mr. Chairman, and I promise I won't take anywhere close to 15 or 20 minutes. Kentucky Power does appreciate the opportunity to address the commission on this matter today. As my friend Mr. Sanford noted, Kentucky Power filed a single opposition to the 8 pending motions, and the reason for it was this. Riverside is a business competitor of Kentucky Power, and Riverside, just like Kentucky Power, sells its energy into the PJM market, and the type of discovery that I've been involved in Kentucky Power's last 3 rate cases is exactly the sort of business-sensitive information that Kentucky Power simply cannot turn over to a competitor. And Kentucky Power will not be in a position to enter into a non-disclosure agreement with Riverside if Riverside were granted the right to intervene. And we feel like that could disrupt the proceedings, but we have a very significant concern about having a competitor in here and the competitor having at least the ability to seek that type of information. In addition, even if that factor did not exist, I disagree with Mr. Sanford's characterization of the issue. It doesn't matter whether the commission looks at the question under the existing tariff or the proposed tariff. Riverside is not eligible to remote supply. The change to the existing tariff that Kentucky Power is proposing in this case doesn't affect the disagreement between Kentucky Power and Riverside, which is whether the Zelda and the Foothill sites constitute 2 sites, as Riverside contends, or 1 site, as Kentucky Power contends. But for the purpose of these remarks, I have a much broader concern, and I think it's one that not only the Commission, but the 2 existing parties share, and that is we've got an awful lot of people that want into this case. In Kentucky Power's last rate case, there were 4 interveners: the Attorney General, KIUC, Walmart, and the School Boards Association. In this case, there are now 10 parties seeking intervention, 2 that have been granted and 8 that are pending. And the way I break the interveners down in this case, the 8, is you have 2 industrial, Riverside and Progress. KIUC is already in here and represents the industrial. You have 1 that's essentially residential, that's the union. And then you have 5 non-industrial and non-residential, that's the commercial utility customers, the League of Cities, the cable folks, Walmart, and KSPA. As the commission knows, discovery is a very important part of any commission proceeding, but most particularly in a rate proceeding. There is a lot of information to be sifted through in a very short, statutorily determined timeline. And as a result, the commission has issued a procedural order that allows Kentucky Power a total of 26 days to answer 2 sets of data requests. In the last rate case, when there were only 4 interveners, Kentucky Power received 911 data requests. As the commission and the parties can probably understand, Kentucky Power was stretched to the limit to answer those data requests. And I think I need to point out that that 911 number doesn't count any of the subparts. And many of the data requests contain anywhere from 2 subparts to 10 subparts. 686 of the data requests, again, not counting subparts, were from the 4 interveners. So it's clear to Kentucky Power that if all 8 pending motions were to be granted, it would be stretched to its limit, and I'm concerned past its limit in being able to answer the first round of data requests in 14 days and the second round of data requests in 12 days. And there has to be some rule of reason that applies here. Now, each of these interveners has come before the commission and said, you know, I'm just interested in this very specific issue, or these 3 specific issues. And there needs to be some way that the scope of discovery can be limited if the commercial customers are only, well, let me say it this way. When you have 11 entities, that would be the 10 proposed interveners and staff issuing data requests, there is going to be a significant amount of duplication. It simply can't be helped. It's not because anybody's attempting to do anything wrong or unnecessarily burden the proceedings, but that's simply the animal that we face. And even if Kentucky Power is able to refer the second, third, and fourth person asking this substantially the same question, it takes time to process that, to understand what's being asked, and to see whether the other, how they differ from the other questions. And again, we're on a very tight time frame. And ultimately, it's up to the commission. The commission knows best what parties will aid it in deciding the issues presented by Kentucky Power's rate case. But we would look to the commission to craft a process and to limit intervention so that the proceedings can go forward, so that staff and the interveners that are in have time to review all of the data responses between the first set, in 11 days between the first set of responses and when they're required to issue their supplemental set. And that's not going to be easy on their part. I recognize that as the applicant in this case, Kentucky Power bears the burden, and it's a burden we're willing to assume, but there has to be some way to control and limit discovery. Perhaps the discovery could be, the scope of discovery could be limited to the very specific issues that these entities have indicated that make them unique if the commission were to allow them in. But I don't think we need 5 commercial interveners in this case. I understand the issues facing progress. But that is, as they say, they're simply, and again, I'm not trivializing their issues at all, but they're an outlier. Their load factor is so horrible. I'm not sure that there's much that can be done about it. But again, that lies in the commission's discretion. The School Board Association was an intervener in the last case, but it's essentially, and there was a pilot tariff developed, and that pilot, the 30 demand meters indicated that that special class really does not need to exist. And I think it's important to recognize that one of the reasons that pilot is so attractive to the School Board Association is there's that $500,000 credit to the schools that are picked up by the other LGS customers. With that, I would simply commend the matter to the Commission's discretion, and we'll await your decision.
Mr. Chandler, do you have anything to say?
Just a minute. Thank you. Making sure there were no other groups here.
You're the only group that's going to say anything.
So good. I thought there may be somebody else. Just quickly, we want to note on the record that obviously under the statutory regime, our mandate is to represent all consumers, and under applicable Kentucky law, that applies to every person, corporate or natural. Due to the limited resources, the AG often finds itself representing those classes who are otherwise inadequately represented. For instance, many of the rate cases the AG is involved in, it just happens that they're involved in, and off the top of my head, probably about half include no other interveners other than the Attorney General itself. And we find ourselves representing all customers and all consumers. And to further show this, you need to look no further than the KU case 2016-370, where the Attorney General provided discovery regarding certain commercial customers, including questions and discovery about seasonal rates to Kentucky utilities. Other than the specific tariffs that we mentioned today as exceptions, we will continue to carry out our statutory mandate to represent all consumers before this commission. It must be understood, though, that the AG does go to lengths in an attempt to keep from taking positions to any significant detriment of customers generally, expressly ones that are otherwise unrepresented. It's also important to note that given the possibility that some of the parties today may not be granted intervention, we want to make it clear to the Commission on the record that the AG does not have an intention of representing any one customer or handful of customers whose interests may be detrimental to those of other customers. Further, we expect that the parties who are granted intervention will carry their own weight, which is why, for instance, for the record, the Attorney General decided to ask all 8 interveners requesting intervention today if they intended on conducting discovery and providing expert testimony on their own behalf. We thank you all for the opportunity, and we look forward to moving on in this matter. Thank you.
Let me ask you one question, Mr. Chandler.
Yes, sir.
Insofar as as I guess a legal officer, when the Attorney General is required to represent all of the ratepayers of the customers, the potential for conflicts exist when one person suggests or one group suggests that this group of ratepayers ought to bear this expense, or when they start allocating costs. Would you agree with that?
It's a tightrope walk.
I mean, it's a problem, isn't it? An ethical problem, perhaps.
It's one created by the statutory mandate.
Yeah. Yes. Thank you.
And I think envisioned under its construction.
Sure. Having said that, Mr. Overstreet, would you have any other comment?
No, Your Honor.
Okay, thank you. All right, with that, we will adjourn this hearing and hope to have a decision as quickly as possible within the next, perhaps, week, 10 days or so. I know time is of the essence in the case. Thank you.
Thank you, Mr. Chairman.